Okay, is this on? Yeah, okay, great. Right, well, hello, good morning and welcome to you all. Thank you for being with us here today, despite the rail strikes, there we go, and general disruption. Really appreciate you making the effort to be with us here. My name is James Wilmot from Forum Europe, and it's our Forum Europe's pleasure to host you all here today for this 12th edition of our annual Data Privacy and Protection Conference, and it's the first edition in person since 2019. We've a packed day, kicking off shortly with a session looking at new tech regulation and how this interacts with GDPR. We've then got sessions looking at considerations for privacy in the context of AI governance, how synergies can be created between data privacy rule books worldwide, and a focus on how understanding of privacy may evolve as future digital services and technologies emerge. We've Commissioner Reynders joining us around 1:45, and we also have an intervention from Grant Harris from the US Department of Commerce this afternoon, amongst a number of other keynotes. Thank you to this year's conference sponsors, Baker & McKenzie, Broadcom, Intuit, ITI, Usercentrics, Meta, and Workday. For those still using Twitter, the hashtag, thank you very much, the hashtag is EUData2022, and the Wi-Fi is the TON hotel network. We'll have roving mics throughout the day, and obviously we want to hear from you, so do get involved. The microphones will be going around, so if you do have a question or a short comment, do raise your hand and we'll bring a microphone to you. And if you do have any questions or if you need anything throughout the day, please just let us know. So with that, welcome, thank you once again, and I'll hand over now to Elizabeth, who will moderate the first session of the day. So thank you very much.
Thank you. Thank you very much. For the first session of the day, we have a very impressive panel, and I have a very difficult mission, is to introduce all the panel members. So I'll try to get all the names right, but please. So I'll start with our first speaker today, Mr. Aleid Wolfson, who is Deputy Chair, thank you, Deputy Chair of the European Data Protection Board. You were appointed Chair of the Dutch Data Protection Authority in 2016, and before that, you had been a member of the Dutch DPA Advisory Board. Then we will have Karolina Mozesovic, Deputy Head of the unit responsible for data protection at the European Commission, and you were one of their Commission representatives in the negotiations of the GDPR with the Parliament and the Council. Then the third speaker today, Ilias Hansos, Global Privacy Officer and Head of Government Affairs Program for Europe, Middle East and Africa of Broadcom. Broadcom is a technology leader that designs, develops and supplies semiconductor and infrastructure software solutions. Our next speaker in the panel, Fanny Idvegi. He is the Europe Policy and Advocacy Director at Access Now, a non-profit organization with a mission to defend and extend digital rights, civil rights of people around the world. And last but not least, Sermin Altinkaya. Sermin is Senior Product Manager within Usercentric, a leading consent management platform that empowers companies to obtain, manage, and document consent of users. So with this presentation of our panel, we will start the discussion today on the GDPR and the new wave of tech regulations, consistency, compliance, and enforcement. And what we'll try to show you with opening remarks and then questions. So please listen to the opening remarks of all our speakers and think of questions you will have to ask them afterwards. I have questions, of course, but all the audience is very welcome to ask questions. So we will look at the GDPR, the new wave of tech regulations, the interplay with the GDPR. We will look at the lessons learned from the GDPR enforcement, how we can take that into account with the new tech regulations, and also look at the complementarity and the consistency between all those regulations that will be key not only for the European digital market and the European digital economy, but also for the protection of our values and fundamental rights. So with that, I'll leave it to Mr. Wolfson for his opening remarks.
Well, thank you, Elizabeth, for this kind introduction. And good morning, ladies and gentlemen. It is my pleasure to be here today and to take part on behalf of the European Data Protection Board, for which I am the Vice Chair. And allow me to begin with sincere congratulations. Congratulations to all of us. Congratulations on the anniversary of the entering into force of the Lisbon Treaty and the Charter. Part of this was, as we all know, the codification of the right to protection of personal data as a new and independent fundamental right. Of course, the old Privacy Directive was already there, but on the first day of December 2009, Article 8 and Article of the Charter, together with Article 16 of the Treaty on the Functioning of the European Union, explicitly brought data protection within the scope of EU law and in general, and within the scope of the fundamental rights of the EU in particular. With the consequence that the entire Charter, the so-called general principles of EU law, also apply when it comes to the automated processing of personal data. And all of this should furthermore, of course, always be assessed in the light of the core values of the EU. Regarding data protection, this day should not be a day without any reference to this historic moment. Back to the EDPB. While most of you are familiar with the EDPB and its work, allow me to briefly summarize our competences, as this is important to set the scene for today's debate on tech regulation. The EDPB is composed of the national data protection authorities of the EEA countries, plus the European Data Protection Supervisor, the EDPS, as an umbrella organization bringing together independent national authorities. The EDPB ensures on the European level the consistent application of data protection law as well as cooperation, including enforcement. The national supervisory authorities, better known as the DPAs, in their turn oversee the application of the GDPR, including the handling of complaints on a national level. These DPAs are independent. Independent oversight is even an essential component of fundamental right to data protection. And these DPAs are responsible for enforcing data protection laws at a national level and at a cross-border level by cooperating through the so-called one-stop shop mechanism. The one-stop shop mechanism is the system of cooperation between competent DPAs for data processing taking place in multiple EU countries. For the majority of cases, the DPAs reach a decision via consensus. Only a small fraction of cases on which no consensus can be reached is escalated to the level of the EDPB, which then can take a binding decision. The way the EDPB is set up, therefore, combines the best of both worlds: strong, autonomous DPAs who are easily accessible to their national citizens and to the executives and staff members of the main establishments of companies, pooled with a close cooperation in the European network. One important aspect of the Charter and the GDPR is the fact that it defines robust principles and rules which apply across sectors to personal data processing. Personal data is qualified broadly. It is any identifier in an information system which is directly or indirectly linked to an individual. We can draw two important conclusions from this. Firstly, many decisions by DPAs concern the tech industry and the way this industry handles data. And secondly, none of the new acts in tech regulation can function without the Charter and without the GDPR. That means that the new acts themselves and their interpretation should be in line with the Charter and with the GDPR. And when it comes to limitations of the fundamental rights to the data protection, these limitations also should be in line with the applicable requirements of the Charter. The Charter and the GDPR and the independent DBAs as an essential component of the fundamental right to data protection is a logical consequence of this, are therefore bound to continue to play an essential role in tech regulation. That the GDPR system is working is demonstrated by the fact that enforcement is picking up speed. Of course, we are familiar with the usual start-up problems. But in the meantime, we established a lot of guidelines on the one hand and see large fines being issued at national level and at the European level on the other hand. So far, almost 500 final decisions have been reached on cross-border cases through the one-stop-shop mechanism. In comparison to these decisions reached via consensus, there have been so far 4 instances in which the dispute resolution mechanism was triggered, and in total, 5 binding decisions were taken by the EDPB. There are 3 more such procedures in the pipeline. These high fines and binding decisions are interesting for several reasons. First, they are the visible proof that the GDPR helps redress a balance, giving individuals an opportunity to enforce their rights against large and powerful organizations. Second, they also show how decisions on cases can be made in a harmonized way at EU level when complex data protection issues are at stake. The role of the EDPB in shaping a consistent interpretation and implementation of the GDPR is therefore essential. Of course, the large fines are only one part of the story. Every month, hundreds of smaller fines are being handed out across the EEA, and big tech is not only the only culprit of these fines. Many cases concern marketing, finances, but also telecom, for example. While the EDPB will continue to issue guidance, and of course, prevention is better than cure, there is also no doubt that credible enforcement is and remains essential to ensure compliance. Enforcement cooperation is therefore a strategic priority of the EDPB. This is why the EDPB, in addition, is the formal cooperation that I mentioned before, has been working actively on further streamlining informal cooperation and broadening its scope. To unlock the full potential of the GDPR, the EDPB put in place new methods of cooperation, such as the Coordinated Enforcement Framework, where DPAs coordinate the preparation, communication, and the analysis of a common enforcement priority that was chosen together. This year, the action was on the use of cloud in the public sector, and next year it will be on the designation and role of the data protection officers. Another example is our initiative to prioritize cooperation in cases of strategic importance. It would take me too far to go into all the details of this new cooperation method or the method whereby we select strategic cases, but we can come back to this during the debate. Allow me to make one final point. At the EDPB, we have experienced firsthand how much work goes into setting up cooperation among different authorities. This, while as DPAs cooperating in EDPB, we had the benefit of our expertise in working together in Working Party 29, which was the predecessor of the EDPB, created by the 1995 Data Protection Directive. Nevertheless, it took several years to adopt guidance to interpret the GDPR, and we needed the experience of the first cross-border cases and binding decisions to map the obstacles and adopt methods to overcome this. At the EDPB, we welcome the new legislative acts, the Data Act, the DMA, the AI Act, the DGA, etc., which aim to ensure greater fairness, transparency, accountability, and oversight of all big platforms that offer services to citizens in the EU. Greater fairness, more transparency, stronger accountability, and enhanced oversight is always something we should welcome and support, of course. However, we also want to stress how important it is to solidly embed DPAs in the overall regulatory architecture that is being developed for the digital market. This is essential because, as I previously explained, these new legislations hinge on the GDPR. There is therefore a need for structured cooperation between the different authorities that will be in charge of enforcing these legislative texts. Structured cooperation is also necessary between EDPB and the board's other advisory committees or high-level groups, which these legislations create at EU level. And in those cases where the designated competent authority will not be the data protection authority, between that authority and the relevant national DPA. Trying to set up cooperation with different authorities supervising different sectors at different levels could turn out to be a real headache. The roles and responsibilities of each authority need to be further clarified, avoiding overlap and unnecessary complexity, while organizing cooperation in an efficient way. We need more details on how the cooperation forums will work in practice to ensure a smooth coexistence of the different legal texts, and the EDPB stands ready to continue to contribute actively within its mandate and competence to the development of the new wave of tech regulation. But most of this is still in the heart of the European legislator and in the heart of the national legislators. Again, we very much welcome the new legislative acts, but it remains key to ensure a solid implementation, to clearly and decidedly choose charter and privacy-friendly interpretation, to offer legal certainty to citizens, businesses and government institutions, and to provide for clear guidance and enforcement. This can only really be successful when all new forms of supervision fits in well with the existing supervision system on data protection. I look forward to discuss this issue with you later on. Thank you.
Thank you. Thank you very much. I think we will have no time today to go in depth into all the legislation, but what we will try to do, and Carolina will try to do that first, is explain the interplay between the different tech legislation, so the DMA, DSA, Data Act, Data Governance Act, with the GDPR, and how they complement each other, and how we will ensure that there is consistency between them. Karina, thank you.
Thank you very much. Good morning, everybody. Indeed, I would like to sketch out a little bit the interplay between different legislative instruments which we have already applicable and which are still, and those which are still being negotiated. Maybe a little bit of step back, where are we coming from and why all these additional instruments? It's all set in the context of this wider European agenda, which is concerning the responsibility of tech companies. And here what we wanted to induce more is the consciousness or create more the consciousness about the role they play in our everyday life. And the second, it's which are the necessary measures to so that presence of these companies on the market in our lives would not impinge on allowing all of us to freely participate, I would like to have it in the digital world. So this new instrument after the GDPR are addressing actually 4 topics, which only 2 or 4 aims, and only 2 of them are overlapping a little bit with the GDPR. Fairness, transparency, accountability, democratic oversight, and creating level playing field. Online intermediaries, and here I think in particular about social networks, video sharing platforms, are becoming the main way of consuming media content. It's all very nice. There is a lot of innovation coming with it, which we are, of course, all of us, we are supporting it. But we are being faced with more problems concerning illegal content and hate speech. And these two elements, this is what the DSA is about, Digital Services Act. It's about, it's not about protection of the fundamental right, how to process personal data. It's about content moderation and liability of intermediaries. In that, particularization, narrowing down for some operators of the possibilities to offer advertisement. There we have these two elements, restriction of the possibility to use sensitive data and minors. Now, the another one, the DGA, and really DSA does not cause as many problems, or there is hardly any overlap with the GDPR from this point of view, because it addresses precisely content moderation, liability, relies on the notion of profiling, but there is maybe aspects, since very large online platforms have the obligation to do the impact assessment of how their businesses impact fundamental rights and freedoms. There is a little bit the question, how does it work with the data protection impact assessment? But apart of that, it's a really very separate animal. DGA, we are all speaking about acronyms, Data Governance Act. Data Governance Act, it's about modalities. It's not changing the legal basis which is provided for in the GDPR. It's not about adding on the top, specifying whatsoever in the GDPR, because DSA did it for the targeted advertisement, as I mentioned. It's about these modalities provided for the infrastructure, for the system to boost competitiveness, so that when somebody has a legal basis under the GDPR, there is a more secure environment in order to share the data. And here we are speaking mainly about the data from the government to the businesses. We have a part on intermediaries and data altruism, but what the DGA is about is to facilitate the use, but not about the obligation to disclose. And I think it's very important. No obligation to disclose. One always needs to go back to the legal basis in the GDPR. So now another and very interesting instrument, Digital Markets Act. Let me start with, first of all, there is a lot of talking about Digital Markets Act. There are only very few addressees of the norm, very few gatekeepers. This act is addressed to the undertakings who are going to be designated, companies who are going to be designated as a gatekeepers by the Commission. Digital Markets Act complements the GDPR while pursuing the objective to provide for fairness and contestability of the markets. What this act was intended, is intended to address, it's to ensure that markets are contestable in the competition terms. It means lowering barriers to entry, not allowing the company gatekeepers to exploit the market power which they enjoy because of the amounts of the data on which they have amassed, and because so many businesses rely on the services of the gatekeepers in order to engage with us. Therefore, we addressed in this Digital Markets Act the fears, the concerns of leveraging the market power, which stems from data collection practices across advertising services. How is it achieved? By a variety of obligations, which are very divided into groups, which are not really, this division into do's and don'ts is not really very correct, but it's sometimes easier just to say it. Very interesting from the point of view of personal data are Articles 6, 8, 9, or 8, 9 or 9, 10, I always forget. The one about the portability, improving of the portability for us, for individuals, when our personal data is being processed by the gatekeepers, improving portability for business users, which is, here is the element of complementing the GDPR, because the GDPR is not about business users, and then reducing for the gatekeepers on the basis this don'ts obligation under Article 5.2 of the DMA, when data of if the data between different core services can be combined and cross-used, this is, and when services are being offered on the basis of this combination on cross-use, the gatekeepers will need to show the consent. And here it's where we have the element of the GDPR. Now I know I have to speed up very quickly about something which is very interesting, and I know Elias will be very unhappy if I don't say something about it. Data Act, because then he will be saying presenting a different point of view. So what is the Data Act about? Data Act, it's again also about fairness and allowing that data value is being tackled in a fair way. It's Data Act is about Internet of Things, the devices, which and devices, and then the services offered on the basis of the devices. I think there is a lot of misunderstanding concerning to which extent Data Act really complements and to which extent it particularizes the GDPR. And there is a lot of misreading concerning, in particular, Article 3 and Article 4. Well, Article 3 is about the obligation that whatever kind of devices, Internet of Things devices, are provided for in the EU, they need to be set up in a way that will allow the users, individual users, but also business users, to take advantage of what the Data Act provides in Article 5, namely the super portability. And there we have the particularization of the Article 20 GDPR. And indeed, in Article 5, we have a beefing up add-on on Article 20. As you know, Article 20 provides for two legal bases on the basis when the data is processed on the basis of consent, contract, then the data can be ported. Well, Article 5 opens it up for us users. Also when the data is processed on the basis of legitimate interest, even legal obligation, consent, contract, I can trigger real-time continuous request to the data holder to send it to the data recipient. So some exclusions for the gatekeepers. I cannot ask to port to the gatekeeper because we do not want to undermine what we are just trying to achieve by the Digital Markets Act. And there in Article 6, some restrictions which are actually not about personal data regulation but industrial policy, that the data recipient will not be able to use the data in order to develop good services competing with the data holder, that the data recipient cannot use tactics which are misleading the data user in order to have the data user to trigger the request. More interesting there, indeed. Well, we have there, one could even say, really add up this new legal basis. But for individual users, for natural persons, for the business users, the Data Act is very clear. Business users need to have a legal basis in the GDPR in order to be able to trigger the whole thing. And actually, it's not really easy to find constellation or cases where the data users will be using the Data Act or triggering the portability request for personal data. Because let's not forget the acts which I mentioned, they cover also, and it's the reason they use different definitions. They do not speak only about personal data, they address also non-personal data. Well, so Data Act has the three groups, business to business, because then we have the front, where we tried to address the problems or why this Article 20 didn't work. Our controllers, so the data holders as they are called under the Data Act, were a little bit reluctant to have this portability work because they were afraid that the recipient will just free write on their investment, on the way they ordered the data. Therefore, Data Act provides for front, fair, reasonable, and non-discriminatory solutions on the basis of which the recipient and the holder will be negotiating how to resolve this business aspect, the removing of the data sharing. Therefore, fairness. It's actually for the Data Act is aiming at empowering SMEs and allowing SMEs to use more the data which is in other businesses. So we have the business to business, me, consumer to business. Article 4, it's about, well, developing the access right a little bit more continuous, because access right under the GDPR, it's one-off. I'm asking, and then I ask again. Here, Data Act provides for this continuous part, and then the portability, which I explained. And there is a part also about the government. Very contested, it's very much discussed now. It was very addressed by the EDPB, EDPS opinion. It is now very much discussed in the Council, in the Parliament, to which extent the government can ask data from the private operators. Where we, the Commission, where we were coming from, we had very much a part of climate transport issues, where personal data is not so much requested, but this situation of COVID, that there could be maybe situations when for public administration, for the government going through the legislative process, it's just not a really very quick solution. But indeed, it is something that is very contested. And of course, and then there is a part on cloud, easier switching between cloud services. And of course, artificial intelligence, which builds on the risk-based approach. We identified high-risk areas such as education, employment, credits, public assistance benefits, law enforcement, migration, asylum, justice systems, and remote biometric systems such as facial recognition applications. Bearing in mind the impact is certain black box artificial intelligence, which is complex, opaque, with a self-learning algorithm and so on. Bearing that in mind, there is improved or developed obligation on documentation and testing of high-risk artificial intelligence, additional obligations of adequate human oversight, reliability, and accuracy of the systems. And I think I will stop there. I will not enter into European health data space, which is also adding up, harmonizing, but not removing the basic, the idea, the structure of the GDPR. With none of what I've mentioned would have been possible without the GDPR. GDPR establishes the base, and then the other acts complement pursuing different objectives. DMA, really contestability of the markets, very competition objective. DSA, intermediaries, liability, content moderations. AI, very specific obligations on black box and additional transparency requirements on high risk. DGA, modalities, and DA, well, I will stop here.
And thank you very much for this overview, because it's very challenging to present all those new regulations in like 10 minutes. So thank you very much for that. It was perfect.
Sorry for
then it will-
overspeeding, but I
No,
wanted
no.
to cover some of them. Yeah.
I think it
And
will
I still didn't speak about e-privacy, which is stuck in the council and the parliament. So this I leave.
maybe Elias, you will mention the e-privacy regulation or future e-privacy regulation, but we will now have a view on from the industry, the business, and how they see the act, those regulations and the challenges and the opportunities as well.
So, thank you, Carolina. Thanks. I have to admit, I don't like speaking from notes, and I had to take notes on how many legislation is there. I had forgotten e-privacy. So thank you. I scribbled that down as well. Ladies and gentlemen, I would like to try to give, if you like, a very practical perspective around some of these challenges, given my role as someone who's responsible for the global privacy program of a global company that does both hardware but also software. So since Mr. Wolfson started with the birthdays, I think it's fair to say that we're now at a phase whereby we've spent about five plus years of GDPR enforcement and application. So we're now at a phase that we've got a pretty good foundation. We're at a phase that we have a pretty strong understanding of what's expected of us to do. And I think it's also fair to say that those that have made the conscious choice to do a good effort to comply have spent the money, have the people, the processes, the mechanics around them. Those that don't comply and partially comply, well, frankly, they're doing it at their own risk at this point. Now, allow me also sort of like a more personal remark. I've been now almost 23 years in Brussels. Actually, one of the colleagues, ex-colleagues from the Commission that taught me about the internet 23 years ago is inside this room. So I can be accused after 23 years in Brussels about many things, opinionated, talking too much, but I cannot be accused, I think, of being inconsistent. And one of the things that I believe I have said consistently is that GDPR is not just about privacy. GDPR is also very much about information governance. And I do believe that right now, with all that regulation that we've seen from the Commission, we're at a critical junction. We're at an inflection point. Why is that? Privacy professionals are at a crossroad because they have to make a conscious choice. Do we position and do we work on privacy matters only as defined by GDPR and as defined by data protection? Or do we pivot more towards information governance and treat privacy and personal data as, if you like, a key foundational piece of a broader data governance structure? As I said, I've always believed that with instruments like GDPR, the European Commission was regulating things like not just how you protect the data of individual, but how products are made. What should people be asking of their vendors? What should the vendors be making in order for those products to meet the customer needs? And what kind of data, how the life cycle blueprint of data inside an organization needs to be. So I would firmly argue that the current wave, shower, pick your choice of words, of EU regulation and EU regulatory proposals around data is clearly pushing us towards the direction of data governance. And by the way, I do understand the logic of why the Commission is doing this. So I do see why and what the driver behind is. I believe that the biggest, if you like, bone of contention doesn't have to do with why do we need to address competition issues around data, or why do we need to address more easy or better access around data flows, or why do we need more cybersecurity. Rather, it has to do with scope and ambition, if I had to pick two words. Because it is that scope and ambition that takes the existing stuff that we've done around GDPR and gently, or less gently sometimes, moving the goalposts and create this ambiguity of what it is that we're supposed to do and how much of what we've already done need to undo, do differently, or change. So I said, I made a list of everything. And again, I stress the point about scope and ambition. Why? Yesterday, I was in another event, as you might see in my LinkedIn profile, where we were discussing about CRA, Cyber Resilience Act. And I began by saying, if cyber resilience was only about IoT, I wouldn't disagree with it. Equally, I mean, I'll pick on Data Act for a second. If the Data Act was only about the data transfers between IoT devices, consumer to consumer, or sorry, consumer, let's say, business to consumer, fine, honestly. The issues is what's on top, what is extra. And again, I understand the need for it to be ambitious. I understand the need to sort of like manage the fact that the proposal will be modified in the regulatory process. But at the same time, we need to balance the ambition with what we've got already in place. So let's look a bit at the overlaps, right? Network and Information Security Directive 2, data breach requirements, which are also in GDPR, 24 hours versus 72, or sort of like the interesting mix that NIS2 creates, as well as supply chain requirements, which we also have in GDPR indirectly, if you like, or through the SECs. CRA, Cyber Resilience Act, privacy by design requirements, which are in GDPR. How do you implement some of that within the CRA vis-a-vis the conformity assessment schemes that are envisioned and harmonized standards that are envisioned? Please note the conformity assessment standards yet don't exist, and nor do we have exactly the conformity assessment bodies. So also putting that in place will be quite a bit of a task. AI regulation, data quality, data management, data security, all of that is linked to GDPR. Data Act, again, legal basis of GDPR. The relationship of consumer versus processor, the government to business sharing, as well as the consumer, the controller versus processor in whatever has to do with the cloud obligations, and more the commercial aspects of cloud as well. I haven't touched at all on international transfers because we assume that they do not concern personal data. Now, if we go into the discussion about how much Data Act is between personal and non-personal, I would invite you to go attend IAPP, in 2023, because half of the sessions that I attended was about what is covered under the Data Act. So, DMA, DSA, DGA, we'll spend the whole day discussing, so I'm not going to touch at all. But I want to touch something that actually was not mentioned at all. And it's a good example of sectoral legislation and its impact. DORA, Digital Operational Resilience Act. We're a large infrastructure provider. We provide mostly to critical infrastructure operators. Finance customers, telcos are important to us. So, GDPR, again, provisions around security, data breach. Article 28, so processor obligations, the contractual terms that we need to accept vis-a-vis our financial customers, supply chain security, data retention and data deletion, records of processing activities. All of that is touched by DORA one way or another. So when I look at all of this, I ask myself, how much of all of this will land on my plate? Because you know what? It's very easy to say, hey, Elias, you're in Brussels. You know about EU stuff. And this is about data, so you do it, right? So, and how much do I want of this? And also, how much can I deduplicate? Meaning, can I take the GDPR infrastructure that I've got already, the ROPAs, the notifications for sub-processors, the processes around data breach notification, the processes around privacy by design, and build on top, so as to take the privacy program and say to the company, look, we're saving you money. In fact, not only we're saving you money, we're actually giving you a competitive advantage, because you can go to the financial service provider and say, yes, I can meet those requirements, here you are. Buy from me. Because in the end, yes, we're also about money. So all these are the challenges that practitioners need to face. And all these are the challenges that I and my team have to grapple. So again, I understand why we're doing some of this, most of this, but regulators, policymakers, dear colleagues that you're in the room and you are talking to regulators and policymakers, let's try to make sure that we have delineation of scope, what it is that we're trying to cover. Let's not try to boil the ocean. Let's make sure that we deduplicate, and let's make sure that the structures we create in one regime, and I must say, I actually feel very close to what Mr. Wolferson has been saying around, the EDPS, the regulators, how all these regulators will coordinate. I mean, what does the finance regulator know about cyber? And that needs to coordinate with the data protection regulator, and they both need to go and talk to the cybersecurity regulator to then come and regulate me as the sort of like critical provider of ICT services. This is going to be really complex. And you don't want me to go into discussion requirements from data protection on encryption versus the cybersecurity requirements on encryption versus the conformity assessment requirement on encryption. This becomes too big and risk becoming unwieldy. So let's make sure we have clear scope. Let's make sure we avoid the duplication, and let's make sure that we can create structures that take advantage of the economies of scale that we've already built with GDPR. Thank you very much. Happy to answer any questions.
Thank you for the view under the business. I've heard you have added NIS2, DORA, Cyber Resilience Act, so I'm sure.
And I didn't say privacy, please notice.
But I'm sure that Fanny Hidvegi will add some more to that and give us maybe a view on the citizen side, on the fundamental rights side of all those legislation.
Thank you very much. Yes, indeed, I'll talk about how these challenges are represented for people, individual and our human rights. Europe is widely regarded as a standard setter since the GDPR and continuing with the Digital Services Act, the AI Act, and many more. But to achieve that highest potential standards and also competitive advantage, we can only do if fundamental rights are at the center of all these legislation. To achieve digital rights for all, we need to cater toward the needs for the most marginalized people who, as you said, you addressed this crowd. They are almost never in this crowd and never in this policy debate in EU institutions. My opening interventions will go back a little bit to Mr. Wolfson's comments and the GDPR enforcement issues, and then I'll talk about interplay between the regulations focusing on the AI Act and the Digital Services Act. And in the end, in my conclusion, I will indeed broaden with two more ideas. One of them is to spark a conversation about the European Commission's role as an enforcer in many of these topics, and the constitutional challenge and crisis that we see to reflect on the Lisbon Treaty a little bit. So the GDPR is facing a really interesting and unprecedented scrutiny for good reasons, but this is not normal, the level of scrutiny after 4 or 5 years in the normal EU legislative cycles. The model of data protection is very much celebrated, on the other hand, because of creating the clarity and rules for data flows on the one hand, and also to put people at control and generally raising awareness for data protection. But the scrutiny, as I said, while a little bit abnormal, but very legitimate. And we've seen really important enforcement issues all around Europe. Thousands of people filing complaints, and they still don't see their data protection rights materialize for two very specific trends. One of them is the slow resolution of cross-border cases that Mr. Wolfson already touched on. And the other one is the differences in national data protection authorities' practices, but also the procedural laws and their very different levels of independence. I think Ilias already described a lot, but I think it's also important to note that this enforcement fragmentation has an impact on businesses as well. From a human rights perspective, the best is we see a minimum compliance, like a bare minimum compliance, and that is not achieved all the time. So we developed very specific recommendations on how to respond to these challenges. For the European Commission, we urged the Commission to introduce new binding measures. Therefore, you can imagine that we are very interested in the procedural legislation proposal. And we welcome also the EDPB's suggestions on that. For the national data protection authorities, there are two areas to very directly improve. First, to challenge the main establishment determination for big tech and really truly allow the one-stop shop mechanism for data processing and for entities that have that main establishment, and have a little bit more nuance on how we determine that. And the second one is to increase the number of joint investigations. And for national governments, the usual complaint: increase the resources and guarantee data protection authorities' independence. I have to say, I'm from Hungary, and you might be aware of the long-term independence issue of the Data Protection Authority. What we see as an interesting political dynamic is that, for instance, they're extremely helpful and active in the EDPB, as we understand, and they take away some of the criticism on the international level that people face on the national level. So moving on to the second point, the interplay, and I'll start with the AI Act. We know that they are very similar in terms of legal basis. They meant to complement each other. And the AI Act also touches on non-personal data, and so it complements the GDPR in that sense. One clear interplay, but also improvement, is shown by the example of Clearview AI, which I'm sure a company many of you heard. It created a lot of their notorious infringements, created a lot of attention from data protection authorities. There are a lot of cases, but all of that is happening after the violation already took place. And some of it is not repairable in these processes, and they take years and years and years. So what the AI Act will hopefully achieve, that it introduces very clear, not just obligations on high-risk scenarios, but bans and prohibitions for areas that are completely incompatible with fundamental rights, which will be a huge addition. Impact assessments were already mentioned by Carolina as an interplay. I would say that we oppose the idea that the GDPR is a risk-based legislation. It clearly has risk-based approaches in data breach management and everything, but the GDPR, we see it as a rights-based regulation, and it is a worrisome trend in all digital files that everything is moving to a risk-based approach, and the US is very clear and clean to jump on that it's a lighter regulatory approach than if it was fully based on fundamental rights. The other relatively negative or unclear interplay in the AI Act is the lack of individual remedy and redress for people, and we'll see how the AI liability rules will address. So there's one more new law that we haven't mentioned. And well, the Digital Services Act, here we can discuss this during the conversation. I just want to say that the e-privacy directive is in place, so please don't forget about it. Just as you said, just because the proposal is because of data retention and law enforcement exceptions for member states are stalled in the council. That doesn't mean that, for instance, for rules on consent, we shouldn't think of the two laws working together. The e-privacy reform should have happened together with the GDPR at the time to address both data protection and privacy, and it's this is where we are, and we hope to push it further. The other, maybe the one-stop shop mechanism and how the DSA improves it, we can keep it for later, just in the interest of time. So I'll conclude with with these two main challenges and trends I mentioned. The European Commission is the guardian of the treaties, and it has a role to enforce the Charter. But it doesn't have a very strong track record of doing that. It is not the strong suit of the European Commission as it is now. One example, which is, for instance, the Pegasus scandal, we see the complete lack of political willingness from the highest political level in the European Commission to have a European-wide response to one of the biggest surveillance and democracy scandal we've seen in the past decades. The other one, which again is beyond the scope, but the rule of law problems and the enforcement of the Charter in that sense, we see too little, too late in that regard. And the Commission outside the European competition law, it's not a typical enforcer, it's a policymaker, it's a co-legislator. And in the Digital Services Act, what happened is that you propose, you write a law, and in the end it comes and bites back, and you're becoming the enforcer. And I believe that the European Commission is really well placed to respond to centralization problems, resource problems. But as we stand, we need to improve the processes and practices to also make it fit for purpose for fundamental rights enforcement. And with that, my final thought is the constitutional crisis. And we see that a little bit in the European Media Freedom Act, where the European Commission, for a very, very good reason, detected the need to protect media freedom in the European Union. But there is no proper legal basis for us to protect fundamental rights, yes, for privacy and data protection, but there's nothing for freedom of expression in secondary legislation that would allow us to have clarity on how to protect these other rights.
Much. And I was sure you would add some acts, and then you add work for the Commission, I understand, as well, and the enforcement. So, no, let's go to our Sarmin Altinkaya for another practical view on the challenges and the benefits of those tech regulations.
Thank you. Can you hear me? All right. So I wanted to share a bit more insight on how all of this legislation are seen from the industry level, like, because a lot of legislation are coming up, and it might raise a bit of panic within the companies, as it was with GDPR, but we had only one. And now it's like a bunch of new legislation coming up, and we need to keep an eye on all of them. But I think the first thing that we need to look at, and Elias mentioned it very well, is to look first of all at the scope of all of this legislation, because as a mid-sized company, like, most of us, we are working on a privacy program, and that's it. If you're a technology platform service provider, yes, you might look at it from a technical side, but if we look at the DMA, it's for the gatekeepers. If we look at the DSA, it's an updated way to like change the e-commerce directive, and is for like companies like cloud providers, search engines, and as Carolina explained all of them very well, is to tackle all of this like illegal content online. So third legislation is the Data Governance Act. That one is obviously to build a bit more trust, to be able to share data, use the data in a useful way for all the business, but all the citizens too, and not, you know, keep all the data as safe as we can and anonymize them and really like raise them in a way that is useful for the entire society. And other important legislation, it's there already, the e-privacy directive, but as a company, to be honest, and being on the consent management side, we are still looking pretty much forward to have the e-privacy regulation there. I remember for the last 5 years when we were implementing GDPR, the marketing size was taking a big part of the privacy program implementation. And I got a lot of questions like, what is consent? Do we need to go back to oral leads, oral customers? What do we need to do? What is opt-in? What is opt-out? And all of that. And now it's even more because the core of our SaaS platform is consent related. So, but I always said, like, we need to not rely only on GDPR, but what we have already on, like, the e-privacy directive. And people were quite confused on, like, we're all talking about GDPR. Why do I still have to look at the e-privacy directive side? And I think, like, having some updated view and legislation with the e-privacy regulation, we are really all looking forward to it. So that will be first thing that as a company we need to think of and look at, really scope. Are we all subject to this bunch of regulations? And then once we have a bit more clear visibility on that, I would just do the same as I did when we had GDPR coming up, is think about, like, as a company, as a tool we are providing to the others, are we subject to that? Do we need to do anything about this new regulation? Another important side, like, do we have enough guidelines? Because I will touch again on that, but we also struggle a lot, like, what is the interpretation that we need to have? Like, and at some point you need to take a decision because the project needs to go ahead and your products need to be developed in a way that you should present it after that timeline, and you don't have a lot of time. So that will be a bit like, we will need to take again a risk-based strategy to implement and look at these new regulations. And last point is about the way we started to implement GDPR and how it continued. And a really good thing that helped me and helped my colleagues to understand GDPR was all the guidelines that came up quite late, I have to say, but it was very helpful. But yeah, until then we had to really, like, take decision on all the gray zones we had. Just to give you an example on things that I managed, like, even the last 6 months, we had guidelines around cookies and trackers coming from the data protection authorities. Very helpful, very practical. But the point is, like, if you take France, they said, okay, you need to have a button on the cookie banner to say you need to proceed without doing anything, so close it. And then you had the guidelines from Italy, which said we need to have the X one. And to be honest, as a service provider, having all of them, a harmonized product to respond to all of these guidelines, you're a bit like, yes, I'm happy to help all our customers, but sometimes we struggle to have kind of harmonized approach. It's all a bit approximately following the same approach, but if you want to be compliant and help each country, each customer on this country, it might be a bit challenging. And now I was just looking yesterday, and that will be my last point of looking at all the authorities and committees that we want to create with this new regulation, like the Digital Market Advisory Committee and the European Board for Digital Service and so on. And I'm like, okay, then many more websites to consult. And yeah, I'm hoping there will not, obviously all of this regulation are coming on top of GDPR, but it's a bit like, for now, we don't know exactly where to look at and how to look at them. So looking forward to the coming months. Thank you.
Yeah, thank you very much. And I think it's maybe very interesting to start the questions with what you just mentioned, because we have seen GDPR, it's nearly 5 years or 4 years and a half. The EDPB has been doing a tremendous job in not only enforcement or helping in enforcement and cooperation, but really issuing guidelines, recommendations, trying to have consistency between all the authorities. And we see it's not always the case. But what will happen in a very, very practical way with all those new regulations? How are companies, businesses, even authorities, public authorities, how are they going to be aware of what's happening under gray zones, and how do you see that from an EDPB point of view? Because you won't be the only competent authority in that respect. So how do you see that in the future?
Yes, thank you for the question. That's one of the big challenges, because we have to be honest. When new regulation is coming in on a national level or on a European level, that's always coming with legal uncertainty. That's quite common, and that's normal. We have to be honest about that. And to provide guidelines on an EU level is, of course, more difficult than to provide them on a national level, because we have to discuss them with all the colleagues in Europe. And there are new supervisors created now by the European Commission, new boards, new advisory committees, etc., etc. And I think I see it as one of our main responsibilities is to discuss with the new supervisory authorities or supervisory authorities with new tasks or new boards how we relate to each other on the first hand, and then to provide as soon as possible legal certainty. And I think that's very important for the private sector. But that is quite a challenge, because most of the new regulations are still pending. It's still in the heart of the commissions. Most of them, I think, only the DSA.
DORA and NIS are adopted.
They are adopted. Yeah, DMA. Yeah. They are adopted as well. Yeah, sure. Yeah. And most of the aim of most of these regulations is, as Carolina summarized, are more or less complementary to the GDPR. But they use same terms, and there's always a danger to interpret the same terms in a different way. That even happens in Italy, and see about the cookie discussion between Italy and France, for instance. So as our main responsibility, I see, to provide as soon as possible legal certainty, provide good guidelines, but it will take some time. So we have to be honest about that. And that's quite normal. And sometimes we will make a decision as a board, and sometimes the judges will annul this and don't see it as a kind of, don't frame it as winning or losing cases. That's quite normal. But it's a huge challenge.
And I'm wondering, from the side of the Commission, how do you see that, and do you have ideas on how to make sure that all these groups or authorities and advisory groups will work together? And I agree, legal certainty, it's key, because I think the purpose of the legislation is to foster the data economy and the digital economy in Europe. If you want to help businesses, you need legal certainty. If citizens have to protect their rights, they need legal certainty. So I was wondering how the Commission is seeing this consistency.
Well, let me take, for example, the Digital Markets Act. You will see in the high-level working group how many different authorities will be involved depending on the obligations which are in stake. And this is done precisely in order to not to have fragmentation of enforcement, but so that all the enforcers, depending on the obligations which the Commission will be evaluating, all those who should be asked are asked. And there we have consumer organizations, consumer organizations, telecom enforcers, competition enforcers. We have mainly a DPB and EDPS. We have media authorities, because this is what the areas of competences of this authority could be touched. And of course, the Commission, as the enforcer of the DMA, moves within the legal framework as set while applying competition law, because DMA is a competition law tool. Will apply these rules in the legal and economic context. And I think there is the opinion of Advocate General in the Bundeskartell versus Facebook case is very interesting. And there he says, well, it's very good, competition authority can do it. Sincere cooperation, ask to the extent there are, and competition authority can apply or interpret GDPR for its purposes. Check with sincere cooperation in the light of the obligation of sincere cooperation with a data protection authority. This is what's said. We'll see what the court will do about it, but it's precisely about that, that the operators talk to each other. And I think that this idea, well, also that different acts sometimes even pursue the same idea. It's not the first time. I would like to hear a mention also, because this is something that is very much discussed in the topic of ne bis in idem. And there, let's have a look at bpost, for example. Very interesting, it's the area of telecom, competition authority, and telecom regulator. And to which extent what the court did say that, how they should cooperate, if they can impose fine, and who should take into account which views. So again, this is, again, very open and soft cooperation, take into account, say how you did it. But it's not exclusion, this is not this chopped off. If this is then only this, then only one authority, because it sometimes does not work. And while enforcing one instrument, different aims are being pursued, although other elements are as ancillary or touched upon, and then one involves another enforcement authority in different ways. I think it's nothing novel. It's now it's just a lot because there are a lot of different proposals, but it was done already before, and seems to work. That it's challenging, we know, but even within the EDPB, as the deputy chair underlined, well, even in the EDPD, even within one member states, we have sometimes differences of opinion who is the controller and processor. So just leaving it a bit by one authority does not mean that there will be no fragmentation of enforcement.
Yeah, and as soon as you have lawyers, you will have different views and
Well,
interpretations. But Elias, you wanted to respond to that?
So let's begin with a positive. It's, you know, no, but let's begin with, well, it's pragmatic. It was very pragmatic, your remarks, in terms of...
I would think that it was also very positive,
Yes.
because I said it will work, the system of the soft cooperation with soft and less soft, but structure, providing for the structure, the process of the cooperation, this helps.
So I'll rephrase. Let me begin with a compliment, okay? So who of you read the EDPB guidelines on data breach notification that were released a couple of weeks ago? I see 1, 2, 3, the updated ones. So I read them, and I have to confess, I went to my team and said, yeah, I agree pretty much with everything that's there. And it does reflect the good practice that we've got. So yeah, that's practical, workable, that's good guidance. So thank you.
Thank you very much.
No, that was really good stuff. I mean, we were, yeah, fine. I mean, you can say that, you know, but overall, yeah. So how can we take this and make sure that when the NIS folks and the DORA folks and the CRA folks are discussing about this, they are more or less aligned to this? That's going to be your job. And that's going to be our challenge. And to take it a step further, do not underestimate the importance of standards and technical work. Let me say a key word that is being discussed in the corridors in Brussels, EUCS, EU Cloud Security Scheme. And the whole discussion around what does this mean in terms of the different controls requirements that there need to be. You know, put the UCS aside and all the debate around sovereignty. How would a standard in practice be implemented? And if that standard is actually fully aligned with that guidance that you would have issued? Because the more the EU is going down technical legislation and sub-delegations, and in the context, for example, of the CRA, we're discussing about, you know, security profiles, then the rubber will hit the road in terms of, is the guidance of EDPB practically implementable in the light of the operational requirements that exist for that particular technology or for that particular service, if I talk, for instance, about NIS2. in breach notice, or the requirements around DORA. Let me also take an additional sort of like, and perhaps a little bit more provocative statement. With respect, but if GDPR is only rights-based, or if it would be rights-based and not risk-based, then it should be consumer to business legislation. It should not be a horizontal instrument. Exactly for the reasons that were mentioned around risk and managing the risk, we need, and that's why I believe that the political choice that was made around GDPR to be it being a risk-based legislation is the correct political choice. Because if it's intended to be horizontal, it needs to cater for the flexibility that is needed on the industry side. And one other remark as well, because we seem to be focused for good reasons, and certainly we're not B2C, we're not on the consumer side, so it's not really our issue, but we seem to be very focused around consent. And again, that's understandable given we are in Europe, and that's understandable given the B2C context. We're not in advertising, we don't sell data. So again, that's not our major issue. But we do have businesses that we cannot rely on consent. Ladies and gentlemen, I'm not going to ask for the consent of the cyber attacker to process their personal data. We've been through this. I'm not going to ask for the consent of the fraudster to process their personal data, because you know what? They're going to tell me no, in which case I'll have to apologize and delete the data. So I'm not going to ask for consent. I shouldn't be asking for consent. We shouldn't be discussing for consent. And frankly, after Ukraine, after all these cyber attacks, after so much EU legislation, we shouldn't be having that discussion.
I think we all agree.
Right.
There are all other bases than consent.
Good.
I'm just
There are
conscious of
limits to
time, and
consent.
I want to. I know it's we are just reaching the hour, but if the room has one or two questions, I'm just looking, or if you want to ask questions, because I don't want that we stay between you and coffee. I know, but yeah, please.
Good morning, Dominic Spada from the American University of Paris. I'm wondering from both the governance standpoint and from a business operational standpoint, if it wouldn't be more effective to have one competent authority that would cover, and manage all of these different legislations that keep coming into place to avoid some of this enforcement fragmentation that you've discussed. Again, both from the commission side of things, from the governance side, and for business operational standpoints and compliance management.
To me, well, first of all, it was developed in a different way. But even if it would be from the beginning on, I'm not sure. I'm not sure because there are different aims being pursued, not only personal data being processed. And so we would have, all these different aspects which need to be brought under one head, to turn it around. Which is the area now of whatever kind of activity where there is no personal data or non-personal data being processed? So what, we would have one regulator for the whole world, for all activities, really. This is unmanageable. Yeah, this is, I think this is precisely the complexity, the fact that already the GDPR was very broad. It's a public and private sector. And then, okay, a separate thing, the police directive and the processing personal data for the purposes of law enforcement. But now in all these acts, we are speaking about tackling different uses or different consequences of using the data. In the DMA, it's just what happens with the market power. How do we address this? Ex ante, not ex post, like us with classic antitrust instruments. With DSA, how do we tackle the responsibility of the intermediaries, of the intermediaries, but concerning not competition so much, and not only personal data, but content moderation and liability, hate speech. This is what is there. DGA, it's okay. It's a little bit more linked to the GDPR, therefore also such a big presence of data protection authorities in there, because it builds completely on the GDPR and just provides for the modalities of data sharing. Data Act, again, there is such a huge chunk of non-personal data in there, also in the DGA, yes. But and actually, the parts of portability in as far as business users are concerned in DA is completely non-personal data. So different considerations, much more industrial policy, and not the questions of fundamental right. It's different. It's very difficult, I think, to have like one enforcer for all of this.
And at the end, I think it's cooperation that will be key. But all those cooperation mechanisms, are we going to have maybe a piece of legislation on how they will cooperate, just to make sure that cooperation works? And I think it's not just for businesses, it's also for citizens. Because if you want to your rights to be enforced, you need to know where you go, to which authority, otherwise, yeah.
If I can just add a point here, and again, from the industry point of view, I think like all of this regulation are obviously not looking at the same thing or tackling the same thing, but when you look at the practical side of it, when we are looking for information, we want to have like ways, like practical ways to get information. So even if we have all of this like responsible entity who are like dragging this new regulation, there should be like more close to the people, more close to the citizen and to the companies, some institutions, some like working groups where we can access and really like ask for information. I remember like when we're talking about data breach, like for the smallest thing, we're like, oh, should we report to the data protection authorities, or how, where, when? And everyone was a bit lost. So I think there is a gap between like these big principles and the practical aspect of like just Q&A based and very like simple questions, simple answers. But yeah, maybe there is no middle ways, but there should be like a way to cover these big principles and practical aspect, I have to say.
And I think just a short adding this, that's why we should improve our cooperation on, of course, on a European level, but also improve our cooperation on a national level between all the different authorities on a national level. And proximity, for instance, is very important for people when it comes to fundamental rights. So there are different levels to cooperate, yeah.
I'd like to comment on three things. First, the awareness raising and trust, as you said. The funny thing, what happened during the GDPR negotiations is the only thing we forgot is to tell people about it. Businesses complained a lot that they didn't see it coming, but that was, I mean, it was complete bullshit, excuse me, like it was very visible and business knew. People didn't know about it, and data protection authorities are still among the very least known authorities in member states, unfortunately. So that's one thing. The second, I think you misunderstand a little bit what I said about the rights-based and risk-based. Processing of personal data is not permitted unless you have the different legal basis, as you know very well. That is rights-based in my approach. There is no such thing as data protection principles not applying in the context when personal data is being processed. The AI Act is the exact opposite. There is a situation when those obligations don't apply at all. And that's what I try to highlight as a difference that was very much conflated, how the two were presented as similar in the risk-based approach. And finally, as you said, the public sector, we focus a lot on big tech and enforcement problems around the one-stop shop for very good reasons. But we almost entirely ignore in this conversation the failures of improved protection in the public sector and for state actors. We see basic data protection principles being violated by governments using COVID data in elections and many other contexts. So I just want to make sure that that stays on the table and we don't only focus on Facebook in Ireland.
Maybe just one final remark for each of you, and then we will have to close. But all the questions you can address to the panel are during the coffee. But just final point on everyone, yeah.
So a quick comment on what Fanny said. Number one, The good news are that under NIS2, the public sector is actually included in the critical infrastructure, so they have to have the security obligations. But, and let's give also the bad news, if I look at the Data Act, the public sector has the right to ask data from companies, including personal data. They have the right to collect them. They claim to place proper security on them. We have no way of auditing them. But most importantly, they have the right to tell us that they've given the data to a third party, but they have no obligation to disclose to us if that third party or they lost the data. So that's interesting. They have no data breach obligation, yet under e-privacy we have a data breach obligation. GDPR, EIDAS, NIS, DORA, I can count, I think, 3 or 4 data breach regimes that we are subject to. So I suppose that means a lot of opportunity for the NGOs to advocate the right thing.
Okay. Sarmin, do you have like final remark?
Yeah, just on what Elias said, again on this data sharing or data access rights of public authorities, I was questioning myself, like we had so long debates about sharing data with the US, adequacy, non-adequacy, and it's not nice because like the authorities can access to the data and they don't have to say anything about this in the US. And with this aspect of the Data Act, I was also questioning myself, like, are we going into that direction of like authorities having the right for exceptional reason to have access to the data and they don't have to say anything, any reason, they just have the right to do so. So are we going into that direction, or is it fair to do that within Europe? So I was a bit questioning myself about that point too, to be honest.
I'm sure Carolina has a final remark on that point. And then okay. Our final remark. Otherwise, I really thank the panel today for the contribution, and thanks to the room.
Test. Hello, everyone. Yeah, I hope you got some energy after the coffee break. Yeah, thanks a lot for being here for the second session on data protection and AI governance. My name is Sebastian Dannassi, and I'm the Privacy and Data Protection Analyst at Kali International, an independent regulatory intelligence provider based in Brussels. I love talking about digital economy, technology, privacy, data protection, fields that I'm covering in my work at Kali International. Today, we've got quite a complex panel, and we are going to hear from representatives from the European Commission, European Parliament, Spanish Data Protection Authority, European Consumer Association, industry, and academia. I want this to be the most interesting panel that you've ever been on data protection and AI. So we are going to pack a lot of insights into this hour. And I really need your help to achieve that, so please get your questions ready. I think that we have a lot of people who want specific questions, and it would be great to hear if you have something to say. We are talking about data protection and privacy issues, right, in the context of legislative discussions around the Draft AI Act, a landmark piece of legislation, first of its kind as a horizontal regulation, which is still under legislative negotiations. The draft AI regulation aims to create binding rules, for certain AI systems. And Margaret Vestager, the Vice President of the Commission, once said, "The AI proposal does not look at AI technology in itself, but on what AI is used for and how it is used." Now, I would like to invite you to raise your hands if you're already working on anything with AI. It could be legislation, it could be algorithms, software, podcast, report. Yeah, some people, yeah, quite a few, thank you. Did you encounter any challenges already in your work? Is there anything complicated? Yes, no? Okay, let's find that after this panel. Yeah, how complicated it is to navigate through this soup of digital policies, as they like to say these days. During this session, we will hear about the latest updates on the AI Act, how the GDPR will interact with the AI Act, how can we make sure that the AI Act and other legislation on data don't make it too difficult for companies to innovate and gather data to train their AI systems. What is the proposed risk-based system in the AI Act? And of course, the elephant may be in the room. How does the enforcement model look like under the AI Act compared with the GDPR? We have around the table Jordanka Ivanova. She is the Legal and Policy Officer in the European Commission unit responsible for AI policy, development and coordination. Jordanka was involved in the team who drafted the AI Act. Next to her, we have Teresa Martinez Sanchez, Head of Innovation Area at Spanish Data Protection Authority. She is currently working on big data and AI matters. Next to Teresa, we have John Miller, representing ITI, a global trade association of tech industry. John is the Senior VP of Policy and General Counsel, and he currently leads the Trust Data and Technology Policy team. ITI is representing the world's most innovative companies since 1916. Next to him, we have Ursula Packer. She is the Deputy Director General of BEUC, the European Consumer Organization, representing 46 independent national consumer associations from 32 European countries. Ursula is currently working on digital policies, consumer rights, redress, and enforcement. Last but not least, we have Francis Crowley, who is currently active in various working groups, such as the CoData Group, where Francis is the chair of the International Data Policy Committee, AI and Visitation Working Group, which is addressing ethical, legal, and social challenges on AI. Topics of data protection and AI governance are close to his heart, as I understood. Now I would like to start with the pre-recorded video from Brando Benifei, an Italian MEP serving his second term. Brando, who is not here with us, is the rapporteur for the AI Act in the lead committee on internal market and consumer protection, IMCO, at the European Parliament. Let's see the video.
First of all, I would like to thank you for this invitation and apologize for not being there with you. Discussing the AI Act is now more crucial than ever, and for this reason, I thank you again for organizing this event. When we think about the relationship between GDPR and the AI Act potentially, at first glance, the AI Act might seem to be in sharp contrast with the data protection regulation. On one hand, privacy by design. On the other hand, the need for lots of data to improve the AI itself. On the one hand, purpose limitation. On the other, the desire of companies to be able to use the data later for other purposes, such as machine learning. But that is, as it was for marketing, also for AI, these principles are only seemingly at odds, requiring only more attention. In fact, we could perhaps think of the AI Act as an evolution of the GDPR, both in its aspiration to become a global standard and its regulatory approach that focuses on accountability, transparency, risk assessment, and the importance of offering an explanation and remedy when automated processes become dangerous to fundamental rights. Indeed, it is the approach of the GDPR and its global success that is way forward for the AI Act to be a similar success. An example. In the AI Act, we have improved certain parts, such as the enforcement part, by avoiding bottlenecks between authorities. Because in order to build the trust necessary for the adoption of AI, we need to be sure that the rules will be enforced in a timely manner. We took up the demands that arose with the example of the GDPR and suggested an ambitious change, giving the Commission the role of European enforcer in specific cases of widespread EU-wide violations or inaction by one member state with an impact on at least 2 other member states. We know that finding the right balance between the need to use personal data to improve AI and compliance with data protection is a real challenge. That is why we support the adoption of synthetic data on the one hand and the need, in some cases, for a fundamental rights impact assessment. I think in this sense that the Data Governance Act and the Data Act will also come to the rescue of companies with a new regulatory framework in which to operate and use data. Another tool that can be useful is undoubtedly sandboxes. For now, sandboxes remain a very open point of discussion with different opinions. For some parties, they should be a place for experimentation, for others, a place to confront authority in order to adjust. Some stakeholders would even like to use them as a free port, not even have to comply with GDPR regulations. Our idea is that sandboxes should only be exempted from the rules of the AI Act and not from the rest of the legislative landscape. We are also working on the strengthening of stakeholder involvement, including civil society or industry organizations, small and medium-sized enterprises, and academia. We want stakeholders to be involved at different stages, from the standardization process to sandboxes and regular consultations with the board. We believe that they can provide important information on developments in the market and society, as well as point out possible problems. This involvement makes the process more collaborative, which will help to develop a more inclusive model for artificial intelligence in Europe. However, we are firm in our position against any use of technology for mass surveillance. Personally, this is an issue that I feel very close to my heart and that not only looks at the cases of Article 5 with biometric recognition by the police, but also to the possible uses in schools and companies against students and employees. Before it is legal or not, it would be unethical and unfair. We are happy that on the issue of surveillance we have found a larger ground with many other parties in the Parliament. This is why constant dialogue with stakeholders is necessary, even after the text is approved. It's a continuous journey that will not end with the approval of the text, but on the contrary, it will begin with it. Technology and innovation only work if they have the human being at the center. That is why we have introduced a fundamental rights impact assessment as a requirement for companies that will use AI tools, strengthen protection for the most vulnerable groups, added basic obligations for all AI systems, including the measures for accessibility. In fact, we think that self-assessment alone is not enough on every occasion, but that in-depth study is necessary. Furthermore, given the impact that these systems can have, we want to introduce more transparency obligations in cases where they are adopted by public administrations.
Yeah, a lot of things already to pack. Thanks to Brando for that message. Essentially, we heard about some main issues or challenges or hopes for the AI Act, right? So the Act, it is called as an evolution of the GDPR, which is set to become a global standard. And the AI Act focuses on accountability, transparency, risk assessment, respect to fundamental rights. And Brando was also referring about the fact that AI Act should become a model on how to regulate AI globally. and this is my first initial question for my panelists here. Can we achieve that? And my panelists will try with you to answer to that question at the end of this session, if we can achieve the AI Act to become a role model as the GDPR for a global stage. That, sorry. Then Brando was talked about the enforcement model, which is to avoid potential future bottlenecks between national authorities, and the European Commission is the solution and will be the enforcer for widespread violation. Let's see if that will work in practice, and how does it look like. And then, of course, he touched upon AI sandboxes, which should be exempted from AI rules, from the future AI Act rules, but should respect other legislative obligations, such as the GDPR. And of course, we heard that the MEPs, the general majority of the MEPs, are against the use of AI for mass surveillance in public spaces. I'm sure that my guests here would like to comment on what Brando just said, but I would give that opportunity later on. But now it's time to hear about their opening remarks before we start the debate and open the floor for your questions. Let's hand over to Jordanka. Please tell us more about where do we stand with the AI, which is the European Commission's approach, and if you see any overlap between the AI Act and other legislative proposals. The floor is yours. Thank you.
Thank you very much, and very happy to be here with so many professionals, experts who are passionate about data protection and AI, because we see more and more that the two are closely interlinked, and with the increasing use of these technologies, we'll have to tackle with issues and bridge together the different communities. So indeed, as was said, and as a representative of the Commission, our position, I think, is very clear when we published the proposal for the first artificial intelligence regulations in Europe that we proposed last year in April, and that was building on a lot of work that was already done for a couple of years with high-level expert group and also white paper consultations. So the involvement of stakeholders in this public dialogue was important before we published the proposal, and it still continues to be very important also today. So that's why I'm really happy that we continue this discussion. And along the negotiation process, it's important to hear all views, and especially also from the perspective also how this would interact with existing data protection legislation and other frameworks. Now a bit for the basics, because also it's the Commission proposal, which is already negotiated 1 year and a half. I don't want to go into the details, but just want to remind our two key objectives. So on one hand, to really create a single market for this technology, encourage innovation, uptake, because we think it can be quite beneficial, including for the protection of fundamental rights, data protection, non-discrimination, others, if it is built well and designed, and we have tackled sufficiently the challenges that we see that are specific to this technology, including certain bias, dependency, autonomy, unpredictability, and others that make it different, and which on basis of our impact assessment, when we looked, do we need another legislation, was assessed as yes, there are certain gaps, there are certain uncertainties and problems, and companies as well as people need to have a clear rules how they should develop, design, market, and then use these technologies so we can really benefit from them and use them for the common good while addressing these challenges and preventing possible risks on fundamental rights, but also on health and safety, because we also see that not all technologies affect only fundamental rights and data protection in particular. There could be also applications where we would also have like safe driving cars, for example, where we could have also safety risks. And with this, we have followed these twin objectives to build trust, legal certainty, and also to address those risks by following a very clear and simple risk pyramid. It was not easy, I'm very frank with you, and there were so many open avenues where we could have gone in our proposal. But we thought that having this clear risk-based approach will help us to really target on the most risky AI applications, taking into account their specific use context, because it's not that AI is dangerous as such, but we really have to tackle the risks. And on the other hand, really limit the burden on companies to the minimum and target, because if everything is high risk, and if you have all these new burdensome obligations for everyone, that would actually might not be so effectively implemented. So with this, we followed this risk approach with certain prohibitions where we have found gaps in existing legislations and complementing to what already we have as legal protections, and also proposing certain requirements for systems that we have tried to identify in a clear list with legal certainty for companies, where they would have to build those high-risk AI systems with certain transparency, data quality, documentation, and others. So this would all have to be designed and before those systems are placed on the market and then widely circulated for use, and we would have some conformity checks. And then we would have certain transparency obligations for others. And with the mind that we should keep this legislation future-proof as much as possible, because we don't know that we can't already now know all the risks, and we should have this flexibility for the Commission in the future to add more use cases based on a clear methodology, impact assessment, and stakeholder consultation along the future, because it's a very fast developing technology. We don't know yet all risks, and it is important to keep this flexibility and ensure this legislation is fit for purpose also in the next 10 years, because we hope we will not have to renegotiate it every 10 years, but we have the right tools to amend it properly. Then there have been also thinking how to make it really operational, to learn from our past mistakes where companies don't know what it means transparency, they don't know what it means data quality. So the idea is really to build on a very well-established systems of harmonized standards, where there is a lot already ongoing in the standardization field, and we can really give the right tools to the companies to implement them in practice. So this will be the next step after this legislation is adopted. And we're working there as well, and there will be also other tools like regulatory sandboxes and others that could be used. Just maybe a final word for the interaction between what is the AI Act and what we already have. Indeed, we have already a lot of legislation that is applicable to AI, so how this act fits with what we already have there is really important, because we should not overlap, we should not create uncertainty for companies and also problems for future enforcement. So we have indeed looked into the gaps. We have tried to already only impose requirements, and in this pre-market phase, not to overlap with what we already have with GDPR, but or also consumer protection and other legislation, but keep this act as additional, complementary, and without prejudice to what we already have there. So I stop here, and I'm very much looking forward to more concrete questions. There are a lot of things also on governance, but it's a topic on its own for another 5-10 minutes. Thank you.
Thank you very much, Jordanga, for these interesting introductory remarks. Just a point here maybe to add, I've seen in a recent presentation published by the Commission that maybe between 80–85% of the AI applications will not even fall under the AI Act, right? Is that correct to mention?
Yes, in our impact assessment, which is accompanying the proposal, indeed, we have tried to really target now the most riskiest applications. So this is, of course, just an assessment, because really examining in the right detail the market at this stage was even not so straightforward, but overall it's 85% that would be at least within what is the Commission proposal.
Okay, so then so then it means that less legal obligations and less stress for companies, right? And they should deal with the other legislative proposal that we have seen: DSA, DMA, DORA, NIS 2.0, and all the rest. podcast. Now, let me hand over to Teresa to tell us more about the work done by the Spanish Data Protection Authority in the AI field and how she sees the relationship between the AI Act and the GDPR. Teresa, the floor is yours. Thank you.
Thank you. Well, first of all, thank you for inviting the Spanish Data Protection Agency to participate in this session. Our director, Mar España, had other commitments, and although she was really interested in attending, it was impossible for her to do so. Well, related to all the discussions from the first session with all regulation, I'd like to begin my initial intervention by stating something that I would like to emphasize as being useful for avoiding misunderstandings between the different stakeholders involved in artificial intelligence and also in the use of massive data in general. The new regulation that is being created at the European level in the scope of data and digitalization does not provide any additional legal basis to justify processing of personal data outside the framework of the GDPR. Going specifically to artificial intelligence, as we all know, the AI Act focuses mainly on high-risk systems, which most of them involve processing personal data. Consequently, these systems will have to comply with the requirements set out in the GDPR. AI systems must observe the highest standards of transparency in the sense of the algorithm's explainability, but not forgetting that they must be explained in the context of the specific data processing that was designed for. When starting the development of an algorithm, it is essential to do so with mature models, where you include all aspects related with governance and accountability in the whole life cycle of the algorithm, from the programming and training phase to the execution. All them, I insist, apply to the specific data processing, considering its nature, scope, context of application, and its ultimate or intermediate proposes in relation to each of the versions to be performed. Also, when designing and developing algorithms, it is relevant to be aware that the use of an algorithm designed and developed by a third party may shape or influence the roles that the GDPR assigns to the processing. The developer's decision-making could make him a data controller, not just a mere processor. In addition, establishing data protection measures from the design and by default, as stated in Article 25 of the GDPR, is essential. I'm not wrong when I say that the AI systems that take into account all these aspects from the early beginning will easily comply with the GDPR and, in fact, will generate more economic revenue to the business. Other important aspect to consider is the very large amount of data needed to train the algorithm, which involves carrying out a data protection impact assessment in accordance with Article 35 of GDPR. An analysis of the algorithm's inference from the data protection's perspective has to be covered, and additionally, following the UNESCO's recommendation about ethics in AI systems, and taking into account the link between ethics and data protection, we propose to include an ethic impact assessment of the AI system. And just to end my intervention, I would like to mention that from the Technological Innovation Division, where I work in the Spanish Data Protection Agency, and with the scarce resources we are very focused on monitoring all the implications of these disruptive technologies on data protection. Currently, in addition to all material related to risk analysis and impact assessment that we have already developed, and we are continually reviewing, updating, and trying to improve, we have also 2 specific guides on artificial intelligence within the framework of the GDPR. One is audit requirements for personal data processing activities involving AI, and the other one is GDPR compliance of processing that embed artificial intelligence and introduction. Both are published in English, so if you want to search in our website. And also, we have created a working group on artificial intelligence that comes with experts from different fields involved in big data and artificial intelligence. And the goal of this group is to identify needs and set objectives to work on. So that's all my thoughts.
Thank you very much for that, Teresa. So it seems that the Data Protection Authority is not only involved in how to check the algorithms and how to check companies that they respect the GDPR, but is also involved in how to improve the AI legislation. And you put people together and working on developing the technology also for the Spanish Data Protection Authority. And I know that the Spanish Data Protection Authority is the first one, maybe in Europe, that published this guide on how to, on the intersection AI with the GDPR, and congrats for that. And I really encourage you to read it. It's a very, very interesting read, and maybe the organizers can share the link to that report after the conference. Now let me hand over to John from ITI to see what's the industry perspective on the AI Act and on how the EU tackles the horizontal approach for AI legislation. John, the floor is yours. Thank you.
Thank you, Sebastian, and thanks Forum Europe for convening this important discussion, and also for all of you for attending. It's good to see so many people together in one room here. You know, just a couple of words about ITI, which I think will help frame some of the remarks. I mean, you know, as you mentioned earlier, Sebastian, we're a global industry trade association representing 80 global companies from across the tech sector. You know, so what that means is hardware, software, various types of digital services, B2B companies as well as B2C companies. And you know, these are some of the most innovative companies in the world. We've heard the Commission talk about how innovation is also one of the underlying goals of the AI Act, and some of these other legislative instruments we'll talk about. And I guess I would also just say that data is not only at the center of a lot of these technologies such as AI, but also, you know, frankly, it's at the you know, it's really at the center of all of these regulatory instruments. You know, I guess we don't need to belabor what I think you and others have referred to as the alphabet soup of all of these regulations. You know, we heard a lot about them earlier, but you know, the AI Act does not exist in a vacuum. But it, you know, alongside the GDPR, and we heard also, you know, the Data Act, the Data Governance Act, this various cybersecurity legislation, you know, EUCS, e-privacy, which, yes, it is still lurking out there, right? You know, data is at the center of all these legal instruments as well, and you know, they really are all regulating different aspects of data use and different risks associated with the data. You know, and even sometimes personal data, but some of them are also regulating non-personal data, as was mentioned earlier. And I think there are important implications, particularly in the context of fundamental rights, for instance, when we consider some of that. The GDPR, of course, focused on personal data, but the AI Act, not only personal data. You know, I do think that and I think this was referenced earlier by Ilias pretty well, that there is perhaps a lack of clarity at the moment in how all of these emerging requirements necessarily fit together. You know, the example was raised about incident notification in the GDPR, or breach notification in the GDPR versus incident notification in NIS2, and you know, also DORA, you know, the Cyber Resilience Act. You know, there are also notifications required or proposed pursuant to the AI Act, so that's very important as well. I did want to say a few words about the risk-based approach. You know, we've heard about that a bit today as well already. I mean, we are certainly supportive of the risk-based approach and trying to target the AI Act as well as these other regulatory regimes toward the most, you know, toward the risks. There are different risks that are at play here, not only risks to fundamental rights, but health and safety, as others have mentioned. I mean, we're certainly supportive of the Commission's approach in Article 7, you know, to identify high-risk AI. That said, we do think that the way that the approach lines up with the annexes currently is not necessarily a perfect match, and that's one of the reasons that we support the work that's been done by the Council and some in the Parliament to include a more precise definition of high risk. based on the role that AI actually has in helping to cause or have those risks materialize. An AI output is immediately effective in some instances, but perhaps it's only related or kind of an accessory in others. It's important to maintain this nuance because we need to differentiate even within high-risk sectors between applications that actually pose some of these risks and some that don't. So I mean, if a truly risk-based approach is needed, our goal is a regulation that's agile and innovation friendly. This was recognized by the Commission, also the AI high-level expert group. I would also suggest that the risk-based approach has other implications and is important in other contexts as well, including actually to help, I would say, protect fundamental rights. If we look at the structure of the AI Act, it's somewhat built on kind of pre-existing conformity assessment and market surveillance schemes that are derived from product safety legislation in the EU, and I think we see this approach a desire in some ways to replicate some of the approach that has been taken to product safety regulation previously in the context of AI, but also in the context of cybersecurity, for instance, and other contexts. And I think it's a fair question to ask as to whether or not these existing structures are necessarily fit for purpose for not only for regulating complex technologies such as AI, but also for protecting fundamental rights, because a risk-based approach is important when you have a regulation that's dealing with different risks, right? I mean, addressing a public safety or a health risk is not the same as addressing a fundamental right such as privacy. So I think we would suggest that risks to fundamental rights are better addressed through a risk management-based system adopted by providers. There are also a lot of different entities involved here. Also combined with transparency and accountability mechanisms by users. This is a more GDPR-like approach, I think. There are some other. Hopefully we'll have some time for discussion, and we can get into some examples here as well. But just to connect the risk-based approach also to enforcement, which is really important. I know we want to talk about that a little bit more. Again, we heard earlier about some of the challenges caused by all of this alphabet soup from a company standpoint. I would suggest those challenges are exacerbated certainly when we're talking about small and medium-sized enterprises, startups and scale-ups and others. But I think an important part of the conversation that I don't know that I've necessarily heard mentioned yet today is the actual regulatory capacity of the government authorities to meaningfully enforce all of this regulation, including the AI Act. I mean, we did hear earlier from Mr. Wolfson about the need for structured cooperation amongst different authorities. That's absolutely the case. I think it's a reasonable question to ask as to whether all of the DPAs across the member states now are, if they are all adequately resourced to really fully enforce the GDPR. I mean, there are some DPAs that have maybe a dozen or two, and some that have 1,000 folks who are working for them. And so it's a really important question about the efficiency of enforcement when we expand that beyond enforcing the GDPR, but consider all of these other regulations, including AI. How is this all going to fit together? And do we have a risk-based approach and allowing us, as we're drafting the regulations, to really target them to the gaps, as was said earlier, but also to the discrete risks that aren't addressed elsewhere are really important, because I think it's going to also help better enforce those rights on the back end. And I know we're out of time. Hopefully we'll get a chance to talk about global cooperation and the need for that as well, because I think that's another important dimension of this. Thank you.
Thank you very much for that, John. So as I understood, you're a little bit concerned about DPA's resources, right, and their budgets. And about ensuring a coherent approach to how to interpret AI Act if we will not have a kind of similar EU body such as the European Data Protection Board, similar to for the AI rights. So we might see different interpretation of the same act in Europe.
I mean, I think my it seems a little bit unclear exactly what how there is a board contemplated of sorts by the AI Act. There does seem to be some latitude in terms of how who the member states are going to designate. I mean, some of them might establish separate AI authorities. Some might say we want the DPAs to do it. And I'm suggesting that before we go down the path of, if we're going to layer additional enforcement responsibilities on behalf of some overburdened DPAs already, we just really need to be precise and not overly broad about what we're asking them to regulate and enforce.
Okay. Thank you very much. I'm sure that Jordanka would like to comment on some of the points discussed here, but let's go to Ursula and let's see which are the main issues of the AI Act when it comes to consumer protection. And I know that in another panel in May this year, Ursula was raising some concerns about the AI Act when it comes to consumer protection. Have they changed during the last 6 months? Ursula, the floor is yours. Thank you.
Thank you very much for this introduction, and thank you for Europe for having the consumer perspective in this discussion. The short answer is no, our concerns have not changed. I think they maybe would have, I think it's fair to say they have increased. So I'm trying to give you a perspective from what the AI Act means for people. And to make it short, I think it really falls short from a decent level of consumer protection. You may know that under the European Union treaties, the Union is obliged to come forward with a high level of consumer protection in all its policies, and this is clearly not the case. Jordanka knows all our arguments, so I think it's nothing new for her. So first of all, the interaction with other legal frameworks is very important, notably with the GDPR, but also with consumer protection law. And this is particularly so because fairness and transparency are long-standing concepts in consumer legislation. And we have a lot of relevance of these concepts, of course, also in the AI system environment and in the AI Act. And if I hear trustworthy AI and ethical AI, and there is a philosopher next to me who's certainly talking about ethics, to be provocative, I often say that, well, the whole focus on ethics in AI is an invention by Silicon Valley, because the first question that we need to ask ourselves is AI legal? Because we have a lot of obligations when it comes at least to consumer protection, when it comes to data protection, which are all fundamental rights. By the way, consumer protection is a is a principle acknowledged by the Charter of Fundamental Rights in Article 38. So consumer protection also belongs to the fundamental rights discussion. So we have a lot of horizontally applicable principle-based rules on how business practices should be transparent and that it should be fair, and they must be fair. But unfortunately, this is not very often considered when we talk about the respective legislations. And the AI Act seems to rely on consumer protection to do the job when it comes to everything that is not high-risk systems, because as you know, there is only a very specific focus in the AI Act on regulating high-risk systems. Everything else is covered, everything that falls under the definition, but is not specifically regulated, except for a very few, very narrow elements of, for example, transparency obligations if you're dealing with a chatbot or these type of things. And the rest is then referred to voluntary, industry commitments, code of conducts that are encouraged to be set up, but of course are only voluntary. So having said that, we are a bit worried about a potential risk of preclusion, because the AI Act is a fully harmonizing system, and that means that everything which falls into that definition, which is very broad, which in principle is welcome, could be precluded which the member states maybe want to do. So that's definitely one of the issues that we have. So at the very least, we need a very clear rule in the AI Act that consumer protection law is not affected, and the AI Act is without prejudice to these protections. Coming to the AI Act, I'm grateful that, John, you mentioned the product safety approach, because that's indeed what the Commission chose, which raises a lot of questions. So the product safety regulatory framework was invented many, many decades ago to make sure that products can travel across borders and that they are safe for people to use them. But of course, it has a very specific structure, and most of all, it treats the things regulated under it as products. And now we're dealing with complex AI systems which have huge impacts on fundamental rights, not only on individuals but also on our societies as a whole. We all know the discussions about certain algorithms that are used on social media, which unfortunately have led to a big problem in terms of polarization of societies, influencing of elections, etc., etc. So there is a lot at stake, and we're dealing with it with a product safety-based framework, which comes with a lot of problems. In terms of the interaction with the GDPR, I was just reading again that the EDPS and the EDPB made an opinion when the AI Act was published, and they suggested that GDPR compliance should be a precondition for all AI systems who want to enter the European market. You know, that normally they would come with a CE mark, which is the symbol for being product safety compliant. And I think that's an excellent idea, but it didn't find its way, I think, also not in the negotiations now. The main focus, I think, is, of course, the GDPR must not be undermined. And there are already specific, well, there is basically one article in the GDPR, which I think has not been mentioned, which is Article 22, which is about automated decision-making, and in particular profiling. And that is, of course, a huge issue for everybody, I would say. Article 22 is certainly very limited. It is very narrow in terms of it only affects so-called heavy profiling measures. That means profiling that has an impact on the legal situation of data subjects or a similar impact. And it, of course, and that's the scope of the GDPR, is limited to personal data. That must be the subject of the processing. Profiling is certainly something where we as consumer organizations would like to see clearer bans and limitations, particularly when it comes to practices where certain vulnerabilities of people could be exploited based on specific profiles, weaknesses, illnesses, psychological problems. We know that this is very easily possible now with the current technology. When certain audiences, certain parts of our society are targeted, I don't need to say that we do not enough protect our children online. They are subject to all these algorithms, they are subject to all these harmful contents very easily, and that's a huge gap still in European Union law, and the AI Act unfortunately doesn't really do anything about that. We are also worried about high-risk applications which are not really covered in the list of Annex 3, financial services, insurances, healthcare. Nothing is really done to regulate these aspects when it comes to the use of AI systems. And don't get me triggered on the topic of enforcement. I don't know how much time I still have, but of course that's a real question mark. Maybe I also think John made a really important point about the resources, and the AI Act is not coming with a clear European framework, which is so necessary. I still think the GDPR in principle has a very innovative, a good system, because there is one decision that comes then for the whole European Union activities of a company in case of cross-border practices. Unfortunately, it got stuck because of the country of origin principle, which is just not the right principle to apply. So the AI Act, hopefully, if what Brando said will then materialize in the final text, will come with an increased European mechanism to address cross-border big infringements, but will, for example, if it's the European Commission, which is likely to have the safeguarding union procedure in its responsibility, will they be able to do this? they have just had a lot of new responsibilities, DMA, DSA for very large platforms, and we know that they don't have the resources, and the member states don't want to give them the resources. So I would like to close with asking, are we going to be credible as a European Union regulation kind of spearheading society that doesn't give enough resources to our institutions, to our enforcers to really do the job? I mean, this is not going to go well if we don't change that approach. I'm closing with that. Thank you.
Thank you very much, Ursula. And I think that on the resources, that's a very important point, because I know that in a recent letter sent by the European Data Protection Board to the European Commission, they were also complaining about their own budget. And besides, they were also complaining about, in general, the budget of data protection authorities. And in September, the European Data Protection Board, they published a report asking all the EU data protection authorities, do you have enough resources? Do you have enough manpower to work and to address all these technological changes? And the main answer was no, not yet. We are still waiting for the resources. But yeah, as you can see, there is some criticism on the AI Act, on the budget for data protection authorities, and on other issues. And I would definitely invite you to prepare your questions and jump into the conversation. But now let's hear from Francis. And I know that Francis, you are working on various projects which involve ethics and sharing personal data, right? And you might soon publish some deliverables which I consider very interesting, like a survey on ethical, legal, policy and societal frameworks of AI, right? Something on data transfers as well, and informed consent. Please tell us more about what are you working on. The floor is yours. Thank you.
Thanks so much, Sebastian, and thank you for having me here. It's a real privilege to join everyone here. Yes, I've been accused of being an ethicist just now. I think rightfully so. I can't hide it. I work with the Good Clinical Practice Alliance Europe, which is really involved with clinical research, clinical trials. And I think clinical research is, basically it's a data-based industry, because all we're about with clinical research is collecting data and processing that data in order to find some solutions for health problems. Within this context, I was quite heavily involved with the discussion on COVID-19, particularly there with regard to data sharing and what we could do about that. Very challenging situation. And more recently, we set up the Ukraine Clinical Research Support Initiative, which also, in fact, involves data and so forth. So I would say within clinical research, what we try to achieve, I think, is a kind of harmonization between ethics and science. And I would say in this context, with regard to the AI Act, what we want to achieve is a kind of harmonization between protections and benefit for society generally. I also chair the International Data Policy Committee of CODATA, which is the Committee on Data for the International Science Council. And we have a working group for the European Open Science Cloud and the Research Data Alliance on artificial intelligence and data visitation, of which we spoke about. For me, the key word in this entire discussion with regard to, be it AI or be it data itself, is utility. So that's the key word. How can we get the highest utility out of our investment, if you want, out of what we create, what we generate, which is the data? So that's the most important thing, is to get the highest utility out of that, while respecting also situations of persons and their fundamental rights and things like that. And I think that's what the discussion in Europe here is about too. It's really about the AI Act and all of these other acts that are coming about, is, I would say, not only building on the GDPR, but also responding to the GDPR. Saying, look, we went first to the citizens with protections. That's the first thing we went with. Now we have to go back to the citizens with benefits as well. And we have to find that And when I mean harmonization, I mean something like there's almost no difference between protecting and benefit. And we should be able to find that sweet spot, if you want, to be able to do that there. For me, I guess really what's interesting are the governance structures. Structures that promote both basic rights, but also societal benefits. And I would say one of the difficulties with the GDPR was it came up with this beautiful system for not only protecting rights, but also expanding citizens' rights, or clarifying anyway what we mean by data rights. But it didn't have enough doorways in it. It didn't have enough pathways open in it to go out and exploit the data, to get the highest data utility we could for the benefits of society. So as an ethicist, let's say in clinical research, I'm not only concerned about protecting patients, but I'm also concerned about getting the medicines to the patients that need it, and developing medicines for patients where there is no treatment or there's not sufficient treatment, which is basically for all patients. We always want to do better with our toolbox. So when we talk about governance too, and I think this is important in this context, it's not only about governance at the government level. It's not only about enforcement, if you want. It's also about compliance on the other hand. So there's a need for governance within society, not only at the level of the government, but also at the level of, say, institutions, within scientific organizations. And there's a need for soft law as well, for guidances and so forth that regulate particular disciplines or particular sectors. I think that's important here. So I think one of the things that's interesting is, with regard to the AI Act, is the role that ethics will play vis-a-vis, let's say, the role of technology and the role of science. And we need to think about that, and we need to think about what kinds of structures that we can develop or further develop in our societies. For example, ethics committees, research ethics committees. We come in with the research ethics committees, we come into a completely new world when we address data, and it is also the case with regard to AI. And then something else that I think we need to think about with regard to this from an ethics perspective and from a legal perspective, which would be a human rights perspective, which I think I see as a merger of ethics and law. And that is the challenge of, I don't know, re-understanding or expanding citizens' rights as they are expounded in the Charter, and then further expounded upon, let's say, in the GDPR, but how we can take these rights, which are generally individual rights, and expand this into populations or specific groups. And that's a big challenge that we have. But AI in particular, it's not so much always addressed to the individual, but it's addressed to a specific population or a specific group. So I think we need to consider that too. And then another aspect with regard to the citizens is this idea of consent. I think what consent gives us is not just, say, agreement, but it's in a certain sense, it's a voice of the individual in a decision-making process with regard to how their data is being used, or let's say, toward the future, how they interact with AI. It expresses, to a certain extent also, I think, the will of the citizen. One of the things that we lobbied for with patient groups during the development of the GDPR here in Brussels, down the road at the Parliament and with the Commission, was this idea of broad consent, so that we could have, let's say, expanded secondary use of personal data in science or in research. It didn't work in the GDPR. It didn't work because I think of the foremost principle in the GDPR, and that is purpose or purpose limitation. So within the context of purpose limitation, it's almost impossible to understand broad consent. And even within the context of consent, it's very difficult to understand broad consent because it's very hard to consent to something that you don't know. So future uses are what we don't know about. So it's very difficult for me as an individual, as a patient, or as a citizen to say I consent to my use of my data for something I don't know about. So, and of course, the discussion on consent and the relationship between the legal basis in the GDPR and consent, we know, is a very complex issue there. But it seems that we have perhaps put too much weight on consent and that we ask too much from consent. And we are also not looking for other, perhaps, mechanisms that would allow citizens to more easily participate in a digital economy with their data for the benefit of the citizens and for the benefit of society generally. So there is a discussion, for example, on a sort of altruism consent, which also makes sense to a certain extent. But we need to think about these expanded ways to go into that there as well. Then just so I just with the EOS Future and the RDA AIDV working group that we have, it's an international group. Now, I think it is going to be important that we discuss, if possible, as well, the international dimension of this legislation that we're looking at. Because around the world today, we see almost every country implementing AI legislation, just as they implemented data legislation. And I think to a certain extent, I mean, Europe can be very proud that the GDPR was enacted in many different countries in the world, or used as a model for many different countries in the world. The Philippines even used a draft of the GDPR when they implemented their legislation. That was a mistake. But but I think Europe should also be looking at windows or doorways in their legislation that would allow for more interaction with legislation in other countries or other regions of the world. Because the data, the AI, it's basically, it's agnostic. It's nation agnostic. It's not related to a region. It's not related. Anybody who can take it and use it, that's who it's for. One of the things we talk about a great deal when we talk about data sharing in science, maybe a key word is interoperability. And I think that's a key word we have here for the legislation in Europe, but also for the legislation that Europe is putting forward and with the rest of the world. Sebastian, thank you very much.
Thanks a lot, Francis, for these complex points. And before starting the debate here, and also please get ready your questions, because we will serve lunch soon for those who are here. For those online, you need to go and take care of that. I would like to ask Jordanka to come back a little bit and to tell us more about the governance model proposed in the AI Act.
Thank you very much. And just I'll take very briefly the opportunity just to react to maybe what Francis just said, reminding that indeed Europe is already looking for those opportunities, how we could actually benefit from greater access and sharing with the Data Act, with the Data Governance Act, and we are trying to complement already the safe protections on the GDPR by really the tools that allows us to use it, and then also looking into identity management and others to allow these benefits from the data. So I think we really try, and we should not forget that AI is also, and GDPR, just parts of bigger puzzles that now is being shaped with the digital rule book. On the aspect of maybe also just because it's linked to governance on the follow-up of the product safety approach, indeed, it is correct, and the simple reason for this is that we really think that AI, what is AI in the end? It's a software, right? And it is aimed to serve specific purpose, and we always claim in Europe that we have this human-centered approach. It should be always the human who controls the system, so we should not have this utopian society where AI is judging, taking decisions for us, so humans should be always responsible, and that's why for us it's logical to look at it as a product. Filling the gaps into existing legislation, including GDPR, means that we have to make responsible those who are designing and selling those products on the European market, to take into account our values, our existing rights, and try to build those systems already in a way that is safe. So we don't see this as contradictory. And yes, it is complementary to already what we have in existing fundamental rights legislation, including GDPR, that applies then for those who are the users actually buying those systems here in Europe, and we have many maybe also among you. And this is also linked to the model of governance, because we don't follow the same, and also risk management, it's already it's part of the obligations of the providers, and then users, maybe they can have more. But looking at the governance model, we also follow the same logic, and it is different from what we have with the GDPR, also because we try to solve problems of ineffective governance. Here in market surveillance, every authority can take action on their territory, so we don't really face just Ireland who is now taking decision for big companies. Every authority, if they see that those products are dangerous on their market, they can recall and they can take decisions. But indeed, having a consistent system, how this is implemented in Europe, is key. And that's why it's part also that the Commission already has a role in the proposed AI Act to ensure this consistency and ensure that one decision that is taken in one authority, we have uniform implementation across the whole single market. So it is already very important, and indeed there are questions, do we need something more for the Commission? Is this system failing with product safety, which is, we have to take into account that it has to remain consistent with other already existing schemes. It will be, of course, one of the questions for the trilogues, but indeed we'll have maybe other opportunities to talk. And finally, to say, yes, capacities are really important for also those authorities, whether they are national or European. This is a key issue because we would not be credible if we don't have them. We have put a specific obligation for authorities that can be designated as for market surveillance by the member states to have enough capacity, human, technical, and all others to perform their duties. They even have to report to the Commission, and we really recognize that we should have a strong oversight. Now there are also a lot of discussions that even in that case, we might need to have some structures at European level that could help them. Like in the Council, there were proposals to have like a pool of experts, to have union facilities that authorities could use. So we do recognize, and we are very much open to look for solutions to solve this issue.
Thank you very much. I see John that wants to react on that. But however, can we all agree that basically the GDPR will apply on entities developing AI algorithms until they are out there on the market, and then the AI Act will be applicable if they will pose kind of a risk, right?
GDPR will apply to everyone on irrespective of the AI Act, and they apply to data controllers and data users. So we don't derogate. What was said also by Teresa is completely true. The issue is that GDPR often applies to the data controller who is just using the system, but not actually this by design principle. It doesn't apply to the manufacturers directly. So I think the logic is that the AI Act actually kicks in before as a product legislation because it targets the provider, but there are also obligations for the users. And we try there to ensure consistency and to fill gaps, but both will apply within their remit and scope of targeted application.
Without prejudice, right? Yes, indeed. John, can I bring you in on this?
Yeah, sure. I mean, well, just on that last point, you know, I do think it's important to remember that AI is more than algorithms, right? It's you know, we often talk about the need to focus on AI systems because you know you've got algorithms. You obviously also have data which I mean the algorithms don't mean anything without the data, right? To either both from a training standpoint and then when they're using the data. You know, and then there's also compute power involved in the equation here too. Yeah, so I mean, the GDPR is definitely not dropping out of the equation with respect to how an AI system might be using or processing personal data, of course, right? You know, I mean, I guess if you wanted to bring me in on the enforcement point as well, you know, just to underscore, and I think your Danka made this point, but you know, when we talk about regulatory capacity, we're not just talking about money and you know the number of people who are maybe working on these issues, but you know, I mean, we're talking about you know complex technologies. We're talking about various different goals that we're trying to achieve. You know, protecting fundamental rights and protecting safety are not the same thing, and so that is why it is going to be really important that we not only harmonize enforcement across the member states to provide greater legal certainty as to what we're really talking about here, but you know, just finding the people. There aren't necessarily, you know, there's not necessarily one person who's working at a DPA or some other regulatory authority who knows about AI and knows about privacy and knows about safety and knows about you know a bunch of other things that might be in the mix here. So you know that again, I would just underscore that's why it's really important that we focus on the highest risk applications in the context of the AI Act, and I think it's also why it's very important that we you know, just again continue to take that risk-based approach, because again, the companies have a role too. That helps shoulder the enforcement burden, frankly, if they're doing an accountable job themselves.
Okay, I see, Ursula, that you disagree. Please jump into the conversation, and please prepare your questions. We will start the Q&A just after Ursula.
I just have to counter a little bit this idea that high risk is the panacea, so to speak, because the list in Annex 3 of these high risk systems is very, very limited, and there is nearly nothing that would affect consumers. I think credit scoring was the only element that was clearly a consumer element that everybody would be subjected to, I guess. But I think the council has taken out credit scoring now, so there is not a lot that remains. So this is one of the fundamental weaknesses of the AI Act, that it only focuses on high risk. There is, as I said before, there is nearly no other regulatory requirement when it comes to other AI systems except those in the Annex 3. And then there is, just to respond also to Jordanka, what we see as the downsides of the product safety approach is that it comes with a whole structure. For example, with the question about self-certification, which is the absolutely dominant model. So in the future, AI manufacturers, they will self-certificate whether they comply with the requirements that, first of all, are safety requirements under product safety regulation. And it depends on the safety regulation and product safety regulation, whether you will have self-certification or third-party certification. So that is the criteria that is used. So it's just really too much focused on product safety, ignoring these other fundamental right risks that we have. And another downside of product safety, it comes with a lot of reliance on technical harmonized standardization. And technical harmonized standardization is made by private bodies, exclusively private bodies, namely the European and the national standardization boards. And these are engineers and technical experts, and they are now tasked with deciding whether a discrimination or bias in processing, whether that is compliant with fundamental rights requirements. So this is all really not the right approach. So we would have preferred a mix maybe, and what could be done, but currently it doesn't seem to materialize, is that there is at least a set of basic principles, like we have it in the GDPR, that all AI systems falling under the definition in the scope of AI Act have to be transparent, have to be accountable, have to be fair, and that this could be partially, certainly for certain high-risk elements, which are not the top high risk, but medium risk, could be further specified. I think that would have made it much clearer and much easier in order to come forward with a coherent approach that really protects people in a more decent way, because now everything which is not high risk, we only have not specific legislation, and unfortunately I'm afraid that will not be enough. Thank you.
Thank you very much. And let's see if do we have any questions from the audience? Yeah, gentleman there in the back. Thank you. Please be very brief with your questions, please.
Surely. I'm Len Hawkes. I'm from Flynn. Two questions. First for Francis. We're talking about the European legislation, but does he think that the proposals in the UK to expand the scope of consent so that it will be possible that consent will be used for further research in science goes in the right direction? Second question, if there's supposed to be, if in the vision that he has, there would be expanded scope for the provision of looking at data, is there a role, it's not a new idea, is there a role for third parties, trusted third parties, to put consumers' consents together within a particular organization and to administer those consents on behalf of the individuals who have subscribed to that trusted third party? Thank you.
Because that's a quite complex question. Do we have any other questions in the room, please? Gentleman over there, thank you. Let's take then another question, and then I will give the chance to panel to answer to your questions. Thank you.
Yeah, okay, thank you. I'm Andrea Mogni, I'm analyst on digital Europe, digital economy. My question refers to the data sharing with the US. The Court of Justice has issued two rules saying that the agreement between European Commission and the US administration is illegal, are illegal. The two cases are Schramm 1 and Schramm 2. Now, last March, there has been a political agreement between the Commission and the US administration, leading to a possible new agreement. My question is where we stand after this political assessment, after this political agreement, where we stand with data sharing with the US. The US is a major producer of data, and all European private data, personal data, go straight to the US because they pass through Facebook, located in Ireland, by the way. So I wanted to know also the role of the Irish Supervisory Authority to check all these transmission of data to the US.
Thank you very much. I think that your question is for the next panel that will tackle EU-US data transfers issues, and we will also have a keynote speech from Didier Reynders, the commissioner who is in charge for that. Do you have a final question for our panelists? Over here we have a wonderful lady that would like to talk about AI. Thank you.
I had a very long question, but I will summarize.
Please.
Mainly, do you feel that like there are all these new obligations put, we feel like this is starting from scratch, but you have these big players that have been for many years collecting data, machine learning, like training their AI. They already have very advanced AI. Don't you feel that these obligations will impact European companies and put us at either at a disadvantage or even more dependent on these US companies without possibility of transferring data? Thank you.
Thank you very much. So here we go with the second elephant in the room after budgeting and enforcement of the AI Act, the EU-US data transfers. Francis, John, if you would like to comment anything on that, please be very briefly. We have exactly 4 minutes and a half. I can already smell lunch and I'm hungry. Please go ahead.
Thank you. So, Sebastian, if I may, I'll respond just to the first question. I think it's a very interesting question. Firstly, with regard to the UK's interest to expand consent outside of its Data Protection Act, I think more towards broad consent. I think we're all interested in how to do that. My question is, and then also, and I think it relates to the second part of your question too, with what I would call maybe consolidated consent, where you can consolidate groups of individuals and they can give that responsibility over to a third party or so. I can just say, working with patient organizations and working with patient organizations in rare diseases across Europe, and so these were very small organizations, small numbers of people, I would say it's very hard to consolidate consent because people feel very close to having their own say about what affects them. So that's my first thought there. And so both with regard to broad consent or expanded consent or consolidated consent, I would say that we need a new model. We need something more. We need to be able to, as a society, agree to a certain set of ways in which we're going to share our data. It cannot only be individually based. I'll give you one example, or one hypothetical anyway. I go to my doctor says to me, "Oh, Francis, you have this new disease, terrible, say COVID, whatever it is, doesn't matter. But don't worry, we can treat it because I can give you this fantastic medicine that we just developed and you can use that." And I say to my doctor, "Well, how do you know that that medicine is good? How do you know it's safe and effective?" My doctor will say, "Well, Francis, I know it's safe and effective because we tested it and all these people volunteered to give their data so that we could test it to see if it's safe and effective." Great. How could I possibly walk out of that doctor's office and say, "I won't agree to use my data in order to better understand the future uses of that same medicine?" So I think we have to come to some kind of another system within society where we can say, as a society, we mandate this here. Just with regard to Schrems 2, I think it's more
Very
Schrems 2.
briefly, because there is another session on that topic, please.
Oh yeah, okay, then I'll pass that.
Okay,
Thank
John, would you like to comment on anything on the big tech companies working on AI?
Well, yeah, sure. I mean, I think, as I think I mentioned earlier, I mean, one of the, I mean, perhaps it's an irony, perhaps not, but I mean, the regulation is going to apply to all companies. It's probably the way, if it is not efficiently focused on, on the risks, and I know we have maybe a difference of opinion on whether the high risk is a good approach or not, but I mean, I guess from my perspective, as at least as I understand it, the AI Act is not, precluding all the rest of these existing regulatory requirements, such as the GDPR or consumer protection laws. But maybe that's a conversation for another day. But I think if the regulation itself is efficiently focused on those risks, then hopefully it will not disproportionately impact companies that have less resources to comply with them. I think also just I think it's also relevant in the international context. I mean, Francis mentioned earlier, that the EU should be looking for windows and doorways. I mean, I think just to give two examples of windows and doorways that I think exist. I mean, one is a main one, which I think is referenced in the regulation, is if you can pin the requirements to international standards, that is a sure way to hopefully make the EU Act meaningful globally, if the aspiration is to have the leading AI regulation globally, but then also other work that's being done bilaterally and multilaterally, at the OECD. Very important work on principles has happened at the OECD, including a very good AI definition that we look to. And important work is happening at the U.S. Trade and Technology Council on AI as well, and they're meeting next week, and we hope that some good cooperation can come out.
They will sign a
well, I'm not sure.
common declaration or something. Right?
We don't know exactly what will happen at this point, but we're hopeful that we will have some good signs coming out.
Thanks a lot. Final question, 10 seconds for each speaker. Can the EU achieve for the AI Act to be a model on how to regulate AI on a global stage? Yes or no, with 10 seconds a time of comments, please.
My 10 seconds are we all hope that this is the case, and we continue the discussion and those efforts that were also mentioned, where we see that yes, Europe was the first to propose, but now actually it's emerging globally that we are looking and recognizing the need for regulation. You have Council of Europe developing international convention. You have indeed great cooperation in OECD, recognizing the need for trustworthy principles and standards, UNESCO also, and a lot of bilateral and multilateral discussions. So we do think that
10
Europe...
seconds up,
yes.
thank you.
Well,
Please.
well, I'm going to be brief. I completely agree with Jordanka thoughts, so...
Thank you. John?
Well, thanks. Yeah, I mean, I think the answer is a cautious yes. If the Act and the Commission and the other stakeholders in the trialogue, stick to a risk-based approach, grounded in international standards, and make sure that it is targeted at regulatory gaps that aren't being covered elsewhere, rather than duplicating what's
Thank you.
addressed elsewhere.
Ursula?
Yes, but only if now I think it's the European Parliament who's going to make some significant changes to have such safeguards like a fundamental rights impact assessment, which is absolutely fundamental, other elements, but we need other countries to take up, because otherwise we are alone, and that will not be possible to keep that position for a long time. Thank you.
Thank you very much. And Francis, 10 seconds, please. 9, 8.
Yes.
Thank you very much. Yeah, just to let you know that we have roughly 1 hour for a lunch break. There will be lunch provided by the organizers in the foyer for those attending in person. And there will be some exhibition booths from User-Centrics. I would like to thank again Brando Benifei, MEP, for his message. To Jordanka Ivanova, European Commission, Teresa Martinez Sanchez, Spanish Data Protection Authority, John Miller, ITI, Ursula Packel-Beuk, and Francis Crowley, NGO representative. Thanks again to the organizers for inviting me as a moderator. Enjoy your lunch. Thanks a lot.
Good afternoon, everybody. Good afternoon, everybody. Good afternoon. If I could ask you all to take your seats and delay your conversations to later on. Good afternoon. Welcome back from lunch, a rather truncated American-style lunch, but it's very appropriate because we'll be talking about transatlantic relations for the rest of the day. My name is Paul Adamson. I'm with Forum Europe. It's my great pleasure to be moderating this next session, the keynote session of today's conference, in the presence of Didier Reynders, Commissioner for Justice at the European Commission. Let me very, very briefly introduce Didier. As you know, he's been in this job since December 2019, I think the 1st of December, so happy birthday, Didier, 3 years old today. And before that, of course, extremely senior politician in the Belgian world, Minister of Defense, Minister of Foreign Affairs, Foreign Trade and European Affairs, Minister of Finance, and Deputy Prime Minister. All those jobs and many, many more. I will not spend time now, precious time, talking about. The Commissioner will make some remarks. If he has time, he'll take 1 or 2 questions. I will not monopolize him. If you have questions, I will give priority to you. So think about that now. Make the most of being in the presence of the Commissioner for data. And we'll take it from there. And we'll start with no further delay. Commissioner, you have the floor if you want to go there. Thank you.
No, thank you, Paul, and thank you also to the organizers for inviting me to take part in this afternoon session on data protection and AI governance. After that, I will go to the European Parliament to discuss about the rule of law. It's a very different topic. And I'm happy to be back after missing this even last year. But European data, including personal data, are key for the well-functioning of the European single digital market to ensure that Europeans can benefit from data processing's full potential. And the Commission therefore developed the European Data Strategy 2 years ago. Since then, the Commission has put forward a package of landmark digital legislations, and some of them are already in force, namely the Data Governance Act, which aims to facilitate the reuse of certain data held by the public sector and to provide rules on intermediaries for data sharing and for data altruism, and the 2 legal initiatives that regulate digital services, including social media, online marketplace, and other online platforms operating in the European Union, the Digital Market Act and the Digital Services Act. These legal initiatives are all about ensuring fairness, transparency, accountability, and democratic oversight, as well as enabling innovation and creating a level playing field. Separately, under the Data Governance Act, work is ongoing to establish common sectoral data spaces, for example, for health data or agriculture, that shall facilitate the availability of data. The final building block to support the data strategy is the proposal for the Data Act, which the Commission published at the beginning of this year on the 23rd of February. The Commission has therefore delivered on its promise to shape the European data economy in a human-centric way. Now, maybe a few words on the Data Act, the more recent of our children in such a field. The Data Act is about ensuring fairness in the data economy by clarifying who can use what data and under which conditions, and thus maximizing the economic value from data processing. It will ensure that a wider range of stakeholders can gain easier access to personal and non-personal data. This will allow more data to be available for innovative use while preserving incentives to invest in data generation. For example, the Data Act will provide regulatory tools for facilitating switching between cloud providers. We believe that access to competitive and interoperable data processing services is a precondition for a flourishing data economy. To achieve this, we will support work on common standards which will help data sharing within and across sectoral ecosystems. I want to stress that none of these digital initiatives would be possible without the GDPR. The General Data Protection Regulation is solidly embedded in the overall regulatory architecture of the data strategy. This means that any access, use, and sharing of personal data in the European Union digital market must be fully in line with all the requirements of the GDPR. One of these requirements is that the individuals must be fully informed by the controller when data about them is shared. And the information is to be provided in a concise, transparent, intelligible, and easily accessible form. The guiding principle of the legislative building blocks of the data strategy is to follow the GDPR's approach. That is empowering people to make choices about their data and obliging organizations to handle them responsibly. Another groundbreaking proposal of the Commission is in the digital sphere is the Artificial Intelligence Act, which is now being discussed by the co-legislator, the Parliament again, and the Council. It is the first of its kind in the world. So it's the same that we have had with the GDPR. It's maybe the first or so legislation of this kind in the world. The aim of the AI Act is to ensure a future-proof, balanced, and risk-based legal framework for AI that protects health, safety, and fundamental rights, while fostering innovation, trust, and AI development across the European Union. The promotion of AI-driven innovation is closely linked to the implementation of the data strategy, since AI can only thrive when there is smooth access to data. The proposed AI Act follows a risk-based approach. We have identified high risk in areas such as education, employment, access to credits, or public assistance benefits, law enforcement, migration, and asylum. But, of course, also the justice systems and remote biometric systems like facial recognition applications. The EU already has rules protecting fundamental rights, but certain black box AI applications are complex and opaque, which can be a challenge because the decision or outcome of the AI system cannot be traced back. The proposal will therefore help to ensure that high-risk AI systems are designed in a fundamental rights compliant way. And the new requirements will ensure that possible breaches of fundamental rights obligations can be investigated and addressed by national authorities and, of course, courts. In the future, it remains to be seen how compliance with these new digital legislative initiatives will be enforced. But the Data Protection Supervisory Authority will play a role in the monitoring and enforcement of the data protection rules contained within. Of course, appropriate oversight of the new rules will be key to their success. And before to stop, I want to add that we have exactly the same process with the GDPR. The essence now is to enforce better and better the GDPR, but also to convince maybe different partners to go in the same direction. And we have many discussions, you know, with our US counterparts, not only about the data flows, but also about a possible federal privacy law in the US. Maybe we'll have the same discussions to see if it's possible also in the US to think about the same kind of approach, to have good legislations about the digital market and the digital developments, because the key word is trust. We want to be sure there's a real trust between the citizens and all the possible actors in the digital world, but also, because I'm in charge not only of justice, but also the consumer policy, the trust from the consumer to different kinds of online marketplace and producers of goods and services. But I'll stop here to allow time maybe for a couple of questions, like you have said, because I need to go to the Parliament to continue different other kind of discussions. And I will start with maybe one question from you, Paul, or a question from the audience if they are. Please. Thank you very much.
Thank you very much, Didier. Yes, I have lots of questions. You haven't got much time, I know, but before I ask any question myself, I did say I'll give priority to the room. Anybody in the room like to ask the Commissioner a question? You, sir, wait for the microphone, which is coming your way. Keep your hand up, please, so we can identify you. Thank you. And please, obviously, give your name and affiliation. Be very much appreciated. Can the Commissioner see you from behind the column? Right. Can you hear him in the room? No, a bit louder, please, or there's always a second microphone on its way. If the guy could run, because we haven't got much time. Voilà, merci beaucoup. No, c'est mieux.
Sorry about that.
Voilà.
Guido Lobrano, I represent ITI. We are the global association of the technology industry. We represent a number of global technology companies very interested in the issue of international data flows. We've recently contributed to an industry statement outlining how the recent executive order from the United States government responding to the need for finding a new framework for transatlantic data flows responds to the needs of the European Court of Justice requirements. Now we know that the next step will be a draft adequacy decision by the European Commission, and a lot of people are wondering when that draft adequacy decision will be published. Thank you.
Thank you.
We will start now the process on our side, because at the end, we were at the end of the process on the US side with the publication of an executive order, implementing acts and other kind of documents. And now we will start with our draft adequacy decision. I mean that we will go to the European Data Protection Board to receive an opinion from the board. We have already explained, of course, the details of the developments that we have had in the last months and in the 1 year of negotiation that I have had with the Trade Secretary and the Attorney General in the US. But we will have also to go to the member states, to have the green light of the member states, and then there is a possibility for the Parliament to organize a scrutiny of our draft adequacy decision. So normally, if I compare with what we have had with UK, after the Brexit it was needed to come with an adequacy decision, we have in front of us at least 6 months. So I will say before the next summer, it must be possible to come with a decision on the adequacy decision. I want just to say that it was a long negotiations. At the beginning, very difficult, very technical. I have some specialists in the room with me. But at the end, I'm sure that we have a robust new system in the US, because it's really possible to apply the same principles than in the GDPR about 2 elements. The first one is to apply 2 principles, necessity and proportionality, in the access of intelligence services to the personal data, if it's needed. And the second is to have a real judicial review organized by the executive order, but with many safeguards. And we'll see an important role for the PCLOP, so the independent agency, in the entire process. And that's very important to us. But again, we will try to go to the end of the process before the summer next year.
Thank you, Didier. Any more questions before anybody? Yes, yes, madam, yes. Keep your hand up so we can see you. There you go. Thank you. Hope the microphone works. No.
Hi.
Yeah, thank you.
I'm Anna Ferguson. I'm from the American University of Paris. I was wondering if you had any concerns about enforcement falling behind in the same sense as the GDPR, and if so, how would you go about addressing those concerns?
But the enforcement is the most important part, of course, when we have a new legislation. That is very clear, because we need to harmonize the situation in the EU. So it's the reason why we are working, when it's possible, with a regulation to be sure that it's with a direct effect in all the member states. And for the moment, you know that for the GDPR, we are working with data protection authorities in the different member states and a board at the European level. What we try to do now is to enforce the GDPR more and better when there are important cross-border situations. And so on the request of the European Data Protection Board, we will maybe amend the regulation to try to change some procedural rules to be more effective about cross-border situation. When you look to other kind of legislations, like the DSA, to be concrete, we try to work in the same way. So to give some competence also at the central level, so at the EU level, to enforce the new regulation. Of course, it's all the time a debate in Europe to have a decentralized organization with the presence of different kind of enforcement authorities in the member states, but to have also real capacity at the level of the EU. In the DSA, it's more for the Commission to take the floor. In the GDPR, you know, this is more the responsibility of the EDPB, but we'll try also to enforce better at the EU level. So that's the way forward. I know that there are some concern about different kind of applications in different places in Europe, but maybe less than the same remarks in the US. I'm sure that there are more differences between the different states in the US than we have in the European Union between the member states.
Any more questions from the floor? Because I have, yes, madam, yes, again. Perhaps you could stand as well, that to be, so we can really see you and hear you.
Thank you. Sam Choi from Covington and Burling. Do you have a sense of the timeline for the AI Act?
Thank you for such a short question.
It's in the hand of the co-legislator, but I don't have a precise idea. I will ask, maybe I have Lucrecia and Bruno in discussions
Bruno,
now.
do you have an answer?
The timeline about the AI Act, what do you think about the possible evolution? I prefer to ask to the team.
It's still ongoing, and it's difficult to judge when the negotiations will finish.
So to give you an example, we have started in 2018 to discuss about the access for the prosecutors to e-evidence, and we have had an agreement this week. But I'm hoping that it will be faster for the AI Act.
Right. Okay, I'm going to ask you one last very quick political, as much as a policy question, Didier. And maybe is with your DNA still in your body from as a former foreign minister as much as a current commissioner. To what extent can the issues that you deal with across the Atlantic, like data flows, can they be kind of hermetically sealed against the backdrop, let's be clear, about growing tensions across the Atlantic? For protectionist nature, the Inflation Reduction Act, for example, is it possible to have ongoing serious goodwill discussions on the issues that concern you most in particular against the backdrop of these growing tensions?
Well, it's not easy, of course, but we have tried to develop a network of data flows with different partners. You know that we have the most important data flows with Japan, not China, with Japan. We have had an adequacy decision about South Korea. And so if we are doing that, it's normal that we try to have a real good adequacy decision for the relations with the US. Of course, the global context has an influence, but you know that we are working together against the aggression of Russia in Ukraine, and there are a lot of things to do together with the US and other partners in the G7 and with others. There are also some tensions for the moment due to the different ways to fight against inflation. You have mentioned a specific act. We have also some discussions about the energy prices, because for many Europeans it's quite strange that it's possible to have such a huge difference between the energy prices in the US and when there is possible to export some LNG to Europe. But we have tried from the beginning, and myself from the beginning of the negotiation with the US, to be very pragmatic and to work on facts and figures. Is it possible to see if we have a full compliance with the requirements of the Court of Justice? So it was more a legal issue, and we have tried to stick to that. Of course, when we will discuss with the Council, with the Parliament, maybe with the scrutiny, it will be different, but I will try to stay on such a line. My request is to be sure that the protection that we have organized in Europe is traveling with the data to the US. And if it's the case, we need to go to a positive adequacy decision and not take into account different kind of issues. I'm sure that we'll try to maintain such a position. It was a position of the Commission to say at the beginning of the year between the President of the Commission and the US President that we had an agreement on principles, and then you have seen that we took some months to go to the executive order, but it was only a discussion about a real translation of the agreement in principles in legal text, and we'll continue to work on such a basis without too many interference from other discussions, because if we are doing that, we'll stop maybe all the different processes, and it's not the goal. The goal is to organize a very good data flow with, again, a real trust for European citizens to let their personal data going to the US if it's needed.
Thank you. Well, we promised to let you go at 10 minutes past 2, and your boss is there looking at you anxiously because you have to go to the European Parliament. Thank you very much indeed.
My pleasure.
Again,
thank you, Paul.
for the Commissioner, please. Okay, moving rapidly on, we're now going to listen to and watch Grant Harris, Assistant Secretary of Commerce, Industry and Analysis at the International Trade Administration at the US Department of Commerce. It'll be a message we'll get on the screen. Just very briefly to introduce Grant in his absence, the Assistant Secretary of Commerce for Industry Analysis, appointed by President Biden and confirmed by the Senate in April of this year, officially sworn in 2 weeks later. Grant leads a staff of more than 225 trade and industry experts that produce innovative, high-quality, in-depth trade analyses and develop strategies to maintain the leading competitive edge of American industry throughout the world. Okay, so somebody can maybe cue the message. Thank you very much.
It is a pleasure to be with you all today, alongside our esteemed counterparts from the European Commission, with whom we work so closely on mutual data protection and privacy priorities. As many of you will know, the executive order enhancing safeguards for United States signals intelligence activities and the accompanying regulations from the Department of Justice implement the U.S. commitments made in the deal in principle announced by President Biden and President von der Leyen in March 2022 on the EU-U.S. data privacy framework. The EU-U.S. data privacy framework represents the culmination of a joint effort by the United States and the European Commission to restore stability to transatlantic data flows following the Court of Justice of the European Union's 2020 decision in the Schrems II case. The changes in U.S. law resulting from this arrangement will apply to transfers of personal data from the European Union to the United States under the future adequacy decision that the Commission is working on to restore legal certainty to transatlantic data flows. I'd like to run through some hallmarks of the executive order and the accompanying regulations, which strengthen the privacy and civil liberties safeguards governing U.S. signals intelligence activities. They establish a new redress mechanism and enhance rigorous and layered oversight of signals intelligence activities. For example, the executive order requires that signals intelligence activities shall take into consideration the privacy and civil liberties of all persons, regardless of their nationality or wherever they reside. On that basis, the executive order requires that signals intelligence activities be conducted only when necessary to advance a validated intelligence priority, and be conducted only to the extent and in a manner that is proportionate to that priority. The executive order also requires the establishment of a multi-layer redress mechanism with independent and binding authority. Under the first layer, the Civil Liberties Protection Officer in the Office of the Director of National Intelligence will conduct an initial investigation of qualifying complaints to determine whether the executive order's enhanced safeguards or other applicable laws were violated, and, if so, to determine the appropriate remediation to be taken by the intelligence agencies. Specifically, the executive order provides new authorities and protections to the Office of the Director of National Intelligence, Civil Liberties Protection Officer, to ensure that its decisions are binding on the intelligence community and that there is no interference with its investigations. As a second layer of review, an independent and impartial data protection review court established by the Attorney General will review the Civil Liberties Protection Officer's decisions and issue binding decisions regarding whether there was a violation and, if necessary, will direct the intelligence agencies to take remedial measures. Judges on the Data Protection Review Court will be chosen from outside the U.S. government, have relevant qualifications, enjoy removal protections to ensure independence, and review cases free from any interference. To further enhance the Data Protection Review Court's review, in each case reviewed, the Data Protection Review Court panel will select a special advocate with relevant experience who will advocate regarding the complainant's interests and ensure that the Data Protection Review Court is well informed of the issues and the law with regard to the matter. The redress mechanism will be available for complaints transmitted from qualifying states, which is defined to include a regional economic integration organization, which will be designated by the Attorney General based on, among other things, the conclusion that the state provides appropriate safeguards in the conduct of signals intelligence activities for U.S. persons' personal information. The executive order requires U.S. intelligence community elements to update their policies and procedures to reflect the new privacy and civil liberties safeguards contained in the order. The entire process will be subject to oversight by the Independent Privacy and Civil Liberties Oversight Board, which will review policies and procedures of the intelligence community and conduct an annual review of the redress process, including review of whether the intelligence community has fully complied with Civil Liberties Protection Officer and Data Protection Review Court determinations. While there are many features of the executive order that I could discuss today, I cannot emphasize enough how on both sides of the Atlantic we worked on designing a solution that fully addresses the concerns the Court of Justice of the European Union raised in its Schrems II decision. The strengthened safeguards for signals intelligence activities, new redress mechanism, updated privacy principles under the EU-US DPF, and the future adequacy decision of the European Commission will restore stability to the data flows that thousands of US and EU firms depend on, which is the lifeblood of the $7.1 trillion transatlantic economy. The European Court of Justice's Schrems II decision was solely focused on government access to data. The court did not question the protections the Privacy Shield principles offered EU individuals in the commercial sphere. Under the EU-US data privacy framework, participating companies will continue to be required to adhere to privacy principles that provide protections for the personal data of EU individuals, including the requirement to self-certify through the U.S. Department of Commerce. We welcome companies to reach out to the Department of Commerce with questions. Thank you so much for the opportunity to join you today. My team and I look forward to following the discussions inspired by this conference.
Well, thank you very much, Grant, even though you can't hear us. Thank you for that. This is the end of the keynote sessions, so my job is done, except to welcome Friedrich Befelder from the Brunswick Group, who will moderate the next session. I invite Friederike and her panelists to take my place on the stage. Thank you very much.
Welcome, everybody. We've made it this far. Welcome to the third session of today, dealing with transatlantic and trans-channel, I guess, data flows. I'm very pleased to introduce this session. In the interest of time, we have until about 3:30 today. I'll keep my introductory remarks short and just introduce the speakers who I have with me here on stage, which are Bruno Gencarelli, who I think is familiar to many of you in the room. He is the Deputy Director for Fundamental Rights and the Rule of Law and the Head of Unit for International Data Flows and Protection at DG Just of the European Commission. We have Joe Jones, who's joining us virtually today, who's the Deputy Director for International Data Flows at the Department for Culture, Media and Sport of the UK Government. On my left, there's Barbara Cosgrove, who's Vice President and Chief Privacy Officer at Workday. On my right is Sebastião Barros Valle, EU Policy Council at the Future of Privacy Forum. And last but not least, Angel Serna, Senior Vice President for Political and Government Affairs at Zurich. Without further ado, I'd like to just ask every one of the speakers to please provide some short opening remarks, and Bruno, we'll start with you.
Well, I will try to be hello everybody, I will try to be as brief as possible also because I will have to leave 15 minutes before the end of this panel. You've heard the Commissioner, and I'm very happy to answer any other questions the audience might have on the deal. We are indeed moving forward with respect to which we are moving forward as regards the US, but what I want maybe to stress is that this is a part of a broader agenda of the Commission on safe and free data flows. I think that today there is an increasing understanding, and I would say almost consensus at international level, that developing strong privacy safeguards and ensuring the free flow of data are complementary objectives. And it's on that basis that we are working and we are developing this agenda. And this means it's a key element, of course, of our GDPR agenda through the use of the whole toolbox, from adequacy decision to model clauses, where we see, by the way, interesting opportunities in terms of developing bridges between model clauses that are developed by several regional organizations or networks around the world, and that's very interesting because that, for instance, allows us to go beyond the bilateral dimension and have this sort of network effect. So that's an example of new opportunities in this area. It's also part of our trade agenda. The EU, in all its trade negotiations, bilateral and multilateral, has a strong commitment to data flows with provisions that, for instance, prohibit the forced localization of data. That's what we have included in our agreement with post-Brexit agreement with the UK, the TCA, Trade and Cooperation Agreement. It's what we have agreed with New Zealand or Chile, two examples of very recent trade agreements. And it's also about working at multilateral level on an issue that was discussed both by Commissioner Reynders and by the video message we just watched, the question of government access, which a few years ago was probably only seen as a relevant issue from an EU perspective when it comes to data flows, i.e. ensuring that data is protected through the life cycle of the processing of data, including when it's accessed by government. And now we see that this is an issue which is important on the international agenda. We see organizations such as the OECD, for instance, saying, well, if we want to have sustainable data flows, we need to agree on a set of principles that apply to that area. And those set of principles will be adopted in 2 weeks by the OECD Digital Ministerial. I'm mentioning this because often when I am participating or listening to this type of events, public events, I hear a lot of remarks, sometimes complaints, more laws, more privacy laws means fragmentation, etc. Reminds me of what Carolina and myself were hearing when we were negotiating the GDPR. There's always a complaint about rules. Actually, the good news is that those rules are increasingly converging, and that offers new opportunities to facilitate data flows and to also discuss at international level. And that's why this OECD development is very significant. Discuss at international levels and setting standards at international levels on issues that that were considered until very recently as purely national issues, and that's why this OECD exercise and document is unprecedented. So I will stop here, but a few ideas about our work and the work we are carrying out with a number and an increasingly growing number of international partners.
Thank you very much, Bruno. And I guess we'll hear in a minute also some perspectives on if this convergence of rules is really taking place. Over to you, Joe.
Thank you, and good afternoon. I hope you can hear me okay.
All good.
Terrific. That such is the miracle of international data transfers, I suppose. Although it comes with a downside, which is I'm very sorry not to join you in person for this panel. It's a terrific panel. It's always a pleasure seeing and participating in these discussions with familiar and very friendly faces, including those on this particular panel. One of the benefits or the drawbacks of coming after Bruno is that a lot of the stuff that I was going to say has already been said and has been put far more eloquently than I could have put it. But what I wanted to focus on just in these brief remarks was how this year, as we're coming to the close of it, I think has been a tremendously positive and constructive year. We have had turbulent years when it comes to international data transfers and cooperation on these issues, but it really does feel that as I look across the policymaker, the regulatory landscape and the interlocutors that exist in all corners of the earth, everyone has a spring in their steps. People are trying to reach common ground. They're trying to find consensus, and they're doing that in the bilateral space. And Bruno's covered some of those key initiatives in the EU-US context, but there have been lots of other instances where countries are coming together bilaterally to acknowledge or indeed embrace the fact that they do things quite differently when it comes to data protection, but that when you take a step back, what they do fundamentally, whilst it differs in form, the outcome is such that it protects and preserves high standards of data protection. But what's been really heartening this year is we have seen much more in the multilateral space. Bruno is right to mention the OECD's work on trusted government access to data. That has been a very important but also very challenging piece of work. It would be the first time ever, I believe, that governments have come together to articulate what it is they do, first and foremost, when it comes to government access to data, and how what they do is common to one another, and importantly, how it stands in contrast to other international jurisdictions and economies. And that's really important when you think of the inflection points that we've experienced as a globe over the past few years, be that the pandemic, Russia, Ukraine, and beyond. The UK and how the UK sees itself in this. Well, we've got lots of ambition. That ambition recognizes that there is only so much one country can do alone. These are issues that are common to many different jurisdictions, and so we're always very keen to work closely, develop trusted partnerships with our friends and colleagues and neighbours in the Commission and further afield, because these are challenges and opportunities that we need to work on together. So you will often hear from the UK that our work on data adequacy is about building data partnerships, that it's through that work, through those relationships that we are learning about other countries' approaches to high data protection, high data privacy standards. Some of those things that we're learning are actually finding their way into our own domestic policy development. We're going through a process at the moment where we are considering legislation to amend the GDPR in a UK context. Now that evolution of the GDPR, that sort of building on what we know works with the GDPR, is reflecting what we have learned and experienced from other countries and their independent approaches. So the conversation has become a lot more global. The initiatives are feeling more global, they're feeling more mutual, they're feeling more bilateral, and I think that's a really positive step. So I want to just conclude by congratulating, thanking those colleagues and counterparts of mine in different parts of the world, including Bruno for the initiative and leadership on this, and for those organizations, the companies, the think tanks that are really putting ideas on the table and challenging government policy and providing inspiration for what more we can do on this. Thank you.
Thank you very much, Joe. We've heard from the regulator perspective, if I can say that, and I'd like to now pass the floor to Barbara and sort of how businesses feel about this issue.
Sure. Can everybody hear me now? So I'm with Workday. Workday is an enterprise cloud provider for finance and HR. And so as a global company ourselves, we offer solutions to companies all around the globe. And many of those companies themselves have a global footprint. And so for us, privacy protections have been fundamental to us from the start. I've been with the company for almost 16 years now, and I say that because we truly built privacy and security in from day one. It wasn't an afterthought for us. We knew in order for us to get our global customers to trust using our service in the cloud, we needed to make sure that we had a robust program. And we built that based on the European standards initially. And now we've been expanding it to reflect all of the changing privacy regulations as they've emerged across the globe over the past years. We were a strong supporter of GDPR for the harmonization, and we are also a strong supporter of US federal privacy legislation. And as we go through that, we invest heavily in mechanisms for our customers to be able to take the trust but verify approach. So we look at means where our customers can look at our ISO certifications, look at privacy protections built into our SOC audit, so that we can easily demonstrate to them how we built the program and support them. We look at innovative ways of doing it, like the recently approved EU Cloud Code of Conduct that was able to help us demonstrate that our program aligned with GDPR. And we were one of the first companies to certify to that program. But as we look at all these investments and as we look at all of the program, robust data transfer mechanisms are key to success for compliance. You know, for us as well as for our customers, data transfers underpin even the simplest tasks. If we look at it from a finance perspective, for a company to be able to close their books at the end of a quarter across the globe, data transfers are involved. For us, in terms of offering our services as a data processor, our customers expect us to be able to provide support and to be able to do security monitoring 24/7. And to be able to support that, we rely on data transfer mechanisms. And so in terms of European data transfers, we've always offered our customers standard contractual clauses. We're certified to binding corporate rules for processors. We've remained certified to the Privacy Shield framework, even though we understand it's not a data transfer mechanism. We've kept that certification in the hopes that it'll be very easy for us to transition to the new framework when it's finalized and approved. We've also invested in the APEC CBPRs as well as the PRP program to look at it from a global perspective. And over the last year, we've also invested in transfer impact assessments and trying to get our customers the information they need to be able to conduct their own transfer impact assessments and make that easy. But as we look at that, truly the interoperability of the standards is key, and hearing the positive comments about looking to build bridges between these frameworks is incredibly welcome to us. Government to government cooperation also, and things like the OECD Trusted Government Access Program, I think is key to being able to keep moving this forward and keep seeing these data transfer flows. But we're also closely watching to see the global CBPRs and whether advancement of that framework, as well as adjustments, perhaps as the principles go, will help us in terms of being able to truly have interoperability for our customers as they operate around the globe. Maybe I'll take a pause there.
That's great. Thank you very much. And I'd like to pass now the floor to Sebastião, who's going to sort of speak about a range of issues, as I understand.
Yes, indeed, and thank you, Federica, and thank you for the invitation to speak in such a stellar panel. Of course, I'm an EU lawyer, so my intervention will be a little more focused on EU law and local developments. And to start with the upcoming adequacy decision that will be published in draft after the executive order has been published and the DOJ regulations as well. It is definitely needed because companies and public bodies are struggling nowadays with very inconsistent different enforcement trends, both by DPAs and courts around the European Union, and I will touch on that as well. Also important to mention that until there is a final adequacy decision, the combination between the executive order and the DOJ regulations is still not a valid mechanism to transfer data overseas. Of course, this has been made clear by the DPP statement in April, and the fact that the EO and the DOJ regulations have been approved doesn't necessarily change the status quo. It seems that the new adequacy decision will be like the privacy shield, a little sui generis decision, as in it's needed that data importers, so the ones that will receive the data, will be certified under this scheme bound by specific commercial obligations. And it will also be important once the draft adequacy decision is published to understand the reactions by EU regulators, so the DPP. We already seen a couple of optimistic takes from German DPAs that have reacted to the publication of the EO, also with some skepticism in to a couple of points, but in general positive. And taking into account the DPP opinion on the future draft will be important because it's normally very indicative of reservations that the Court of Justice may also express if it is called upon to decide on a new adequacy decision. But to touch briefly on enforcement trends that we're seeing across the EU, we have seen sort of two conflicting trends. One that is very risk-based approach averse, and one that it takes a risk-based approach to the enforcement of Schrems 2 when it comes to, for instance, transfers to cloud providers in the US. So on the risk-averse side, we see, you know, the Google Analytics saga from the Austrian, French, Italian DPAs that mentioned that in those cases there would be no supplemental measures available to website operators that would eliminate the risk of EU citizens' data being accessed by US intelligence agencies. So basically the tone is on eliminating the risk and not mitigating it. And there's also other decisions, notably by courts. We've seen a decision by the French Conseil d'Etat on the Microsoft Health Data Hub case that kind of accepted a risk-based approach to enforcement. Also a Belgian Council of State decision on the hiring of AWS cloud services by Flemish authorities as long as encryption was implemented. And these are all examples of the conflicting enforcement stances that currently are ongoing at a national level. Of course, SCCs and adequacy decisions are not all. There are also new transfer mechanisms that maybe soon become available as the DPB has published guidance on the use of codes of conduct and also certification mechanisms for that purpose, and also very recently a draft recommendation on binding corporate rules for controllers, so other mechanisms may also be used. And maybe to conclude my initial remarks, this is obviously not only an EU-US issue, and we've seen enforcement also by EU data protection authorities when it comes to transfers to other countries. We've seen action by the Irish DPC, which is investigating TikTok's personal data transfers to China, which the company recently admitted are ongoing. And also an action from the Belgian Council of State, so at the judicial level, which suspended a decision by a network of public hospitals to choose a contractor that relied on a further processor based in Russia called Smart Analytics. So this is definitely not only an EU-US issue. If it was, it would be boring. So we have a lot to discuss today as well.
Thank you very much, Sebastião, for this wide-ranging run-through of the various ongoing issues. And last, Angel, I'd just like to hand the floor to you for your opening remarks.
Thank you, Federica. So I represent Zurich Insurance. I stress insurance because I'm not totally sure that when you heard Zurich, everyone is aware what that is. It's an insurance company, so we're risk managers basically, headquartered in Switzerland, but operating effectively a global platform. For insurance, moving data around and exploiting quote-unquote data to get risk insights and optimize and improve our risk management services is and will be always crucial. So you will understand we were typically on the receiving end of what we consider an increasing politicization, an increasing kind of difficult environment that has been generated over the past 10, 15 years following a number of court decisions, which all know. And I think it's not primarily due to kind of to blame politicians, because for lack of trying, if I think of safe harbor framework, privacy shield, now we have another attempt which we're really routing for as Zurich. I'm telling you, the EU-US privacy framework, not for lack of trying, but apparently at the conclusion to which we have come, because it impacts existing business we've been doing for, I want to say forever, we're 150 years old, but allow me that. It impacts business. All of a sudden, we weren't able to conduct and exchange business data, which we use for data insights in the same way we were doing in the past. But it also impacts new opportunities that we saw arise more in the retail space, for instance, travel insurance services, where you really follow with your data your customer, and your customer wants the data to follow him. So for us, kind of a conclusion we came to, and it's always it's a, let's say, an audacious statement probably in a place like Brussels, is that we need to depoliticize the topic to the extent possible. And thinking hard about that, we have 3 suggestions which I think are growingly coming into the discussion and being taken up. But 3 points I would like to make, which I think would contribute to take out the political sting, which probably also owed to the geopolitical backdrop we are living in, sometimes comes into these type of negotiations. The first one, and it all follows from the, let's say, day-to-day experiences that we have in the way we operate our business. We think we should involve much more regulators in defining terms and objective of negotiations and agreements. Let me tell you why I can understand if not everyone kind of immediately nods and says, yeah, why haven't we thought about supervisors, regulators? I think engaging them allows for more specificity. It allows for kind of the technical aspects, the operational aspects gaining more relevance. I think they are crucial at the end of the day because they have to enforce it. And one of the main reasons I will tell you why we think regulators should play a bigger role is the biggest killer of all those fantastic opportunities we are promising you every day the digital age could bring. The biggest killer is actually compliance complexity. In a world where, due to, call it fragmentation, call it proliferation of rules, if they were convergent, I'm pleased to hear that's the goal, then that's one thing. But in such a world, lack of coordination mechanism, lack of coherence in these type of rules is just what, more often than not, is what puts any project to rest. The second suggestion we would like to make is, you will understand, the starting point we would like to see is that these agreements kind of lock in what we think is the pre-existing commitment, the way we operated in the past. Let me tell you, we are since 150 years a properly licensed undertaking. So what we've been doing, it's not that it's been doing in the Wild West or in the free air. It has been clearly embedded in the framework of regulations, very much oriented at consumer protection, and that's correct and right so. And we even understand that with digitalization, you might even need additional carve-outs, exceptions. But there the suggestion would be, let's try to build clear, or to require and establish clear rules and processes around specific commitments, especially when it refers to carve-outs or exemptions. In the sense of, for instance, placing a set of obligations to be required if one wants to impose a particular restriction, not just kind of forcing a clear articulation of the rationale and outlining it, as opposed to giving too much discretionary leeway to happen. And the third suggestion kind of we came up with, and it's something we were pleased to see. Actually, the US reacted in that direction. We heard the Assistant Secretary before. And I know it's actually a deeply European felt ambition, was let's make sure that there are formal mechanisms included that allow for an escalation of complaints to private individual actors. You know, I carefully listened. I had read a bit about it. Obviously, this two-tier redress mechanism that the executive order is introducing, we think it's important. There is a venue to file complaints. It is important that when a decision is taken about those complaints, there's a venue to appeal that, which is what I understand exactly the US executive order is trying to do. Again, kind of introducing or giving regulators a bigger role. One, having clear processes and rules around specific commitments, in particular when it's about deviating from what has been the courant normal. And three, making sure we have formal mechanisms to allow formal complaints to be placed, in our view, would help to take that political sting out to some extent, to depoliticize, as I like to call it, these type of conversation, because this is about future-proofing economies, safeguarding the benefits of digitalization, and there I know and I'm sure we're all on the same boat.
Thank you very much, Angel. And this sort of opens the floor now to Q&A. As Bruno mentioned, he needs to leave in about half an hour. So if you have any questions for him, better get in there early. But maybe I'll just kick things off first. And Angel, Bruno, Angel just mentioned it's necessary to sort of depoliticize the issue of international data transfers. How do you, in your view, how does that go along with sort of the EU's ambition to become, as you know, different words for technological sovereignty, digital sovereignty? How do those two things go together?
First, I'm very happy because I tend to, when I participate in panels, to think that these panels on data flows, at the end, we always talk and repeat the same things. And in general, and here it's completely different because in general, the message I'm receiving is that we should repoliticize and delegalize. This is a too much in an area which is too much influenced by case law, strict legal rules, what horrible things, etc. Sorry to say, but we are. I think it's a good news as we first of all citizens. It's a highly legally weighted area because we are operating within a certain constitutional framework. So I'm not sure what depoliticize means. What we certainly, and here I'm sure we fully agree with Joe, is that we have a system which is both, and we believe in a system, and we are committed to a system which is both, which believe that it's possible to be both protective of data and be open to data flows. And we are working with interlocutors around the world on making that possible. And as I said before, I think there are many more opportunities, and you will see many more instruments, both bilateral and multilateral or plurilateral. There are many more opportunities today than even a few years ago. So that's, meaning, I don't know whether this is, you need to have legal rules, and of course you have a policy. And our policy is that one, is to ensure the continuity of protection and work for a safe and free data flows with a number of interlocutors. And then I also heard something about regulators. Again, very interesting because sometimes I see concerns about that regulators are too much involved in this area. Be assured that regulators on our side are fully associated. They are fully associated, and the Commissioner Reynders explained that before to our decision-making process. Regulators in our system are even developing themselves some transfer mechanism. BCRs, that's an invention of regulators. You mentioned, I think, certification and code of conduct that will be essentially, and we are very happy that they are exploiting the full range of the data transfer toolbox. This will be essentially a regulators type of tool, and that we expecting that will be adapted to certain requirements, features, necessity of certain business sectors or industries. And regulators are very often our interlocutors in international negotiations. That depends very much of how the foreign system we engage with is organized. But for instance, when we were, and we created the largest area of free data flows with Japan. Our main interlocutor was the Japanese regulator, together, of course, with other government agencies. So we indeed believe that they need to be fully on board and fully involved. And according to the type of tools, that always happen with of course, some differences according to the type of mechanism we are talking about.
Thank you very much, Bruno. Still no questions in the room. Please just raise your hand if you do have one. Okay, lady over there. In the grey cardigan. Please just state your name and your affiliation as well. Thank you.
Is this work? Yeah. Hello, my name is Rim Benama. I'm from Proximus. Thank you for the panel. Very interesting discussions. I had a few questions about the next steps on the executive order. During the negotiations that you had, you're probably aware of all the criticism. Yeah, Schrems has been very... I know, but we're not gonna get back into details, but I would like to have your view on, well, mainly the interpretation of proportionality and necessity in the US law and EU law, and whether you see a possibility of it converging. And second question is on the access to the review court. So the access is limited to qualifying states. Is there any news on Europe being designated as a qualifying state? And isn't there a bit of an issue of competence for the European Commission, because one of the conditions is to offer similar level of protection on intelligence? Thank you.
I guess I should answer that. Yes, I'm aware, but we will have now a decision-making process, which is healthy, which is part of our decision, meaning our institution setup, and we will hear, of course, what the other institutional stakeholders, interlocutors, how they will see what we will table in a few weeks. And I've already, of course, we have already engaged with the DPB, with member states, and with others. We will engage with Parliament, of course, but also more generally with the business community and with civil society. That's, of course, very important for us. So very briefly, because we could spend the whole afternoon probably on issues, questions, criticism, etc. But on what you said on proportionality and necessity, I think also for those who are not following that so closely, first what it is about. This is about something that has been explained, that the executive order provides for some safeguards that on the basis that determine when and to what extent intelligence agencies, for very legitimate reasons, to address certain threats to national security, when and to what extent they can collect data. And the criticism is, if I might simplify it, is, okay, we see the executive order, it mentions necessity and proportionality, but is the Commission or the EU so stupid to think that it's sufficiently to refer to proportionality and necessity, and then everybody, the court, the EDPB, will be happy? Well, that's an easy, actually, point to address, because one has to read the executive order, and what is very important with that executive order, and you can imagine that the executive order didn't come out of the blue. We worked very closely with our US interlocutors to translate the agreement principle into US text and now into EU text. That executive order spells out what necessity and proportionality is about. So the executive orders defines and provides for factors and criteria, which will be the one that will be interpreted by the redress mechanism, the two layers redress mechanism. So just to give you an example, if you look at how the executive order address proportionality, it says, well, when, again, an intelligence agency has to consider to what extent it should collect data, using which technique, the executive order tells you, well, a certain balancing of a certain number of considerations has to take place. And what are those considerations? The seriousness of the threat, the likely impact on individuals, the nature of the data, whether it's sensitive data or not, etc., etc. You open any ECJ, ECHR, or Constitutional Court judgment of a European country, when it's the ECHR of the whole Council of Europe, if it's the ECJ of the whole EU system, that's what proportionality is about. and you will find this exactly the same criteria. So, plus, as Commissioner Reynders will mention, there will be a check on the redress system we are creating by the P Club, which is a privacy and civil liberties oversight. There's a word missing, but board, exactly. Which is a fully independent agency in the US that will check on a yearly basis whether this court, whether this new redress mechanism works well, whether it delivers what it is supposed to deliver, whether it works as intended, whether intelligence agencies comply with its decision, whether it applies correctly the executive, the US law, including the executive order. That's, of course, a very important guarantee for us. On your other question, the designation, it's a very good question, and here I fully agree with you. The executive order and the AG regulation are a very important step in this process, and they allow, and they will allow us, and they allow us to very soon propose the adequacy decision, draft adequacy decision. But those safeguards are not yet in place. The safeguard of the executive order that can help, that have been negotiated, that's also very important aspects, regardless of the transfer mechanisms used. Those safeguards will help the use of making more solid and legally certain transfers on the basis of model clauses, transfers on the basis of BCRs, transfers, any actually transatlantic transfer. But for that to happen, those safeguards have to be effectively put in place. And this concerns two elements. The designation that you very well referred to of the EU or the EEA, because this is an EEA as jurisdiction which individuals can benefit from the redress mechanism, and also each and every intelligence agency in the US has to review its internal rules to make sure that those necessity and proportionality requirements are now fully reflected in the way they operate. Those two steps are absolutely essential for the executive order to safeguards to be fully effective, and for companies, including many companies represented in this room, to say, okay, now I can safely use model clauses, I can safely use BCRs, etc., to transfer data to the US. The designation is something we believe we can perfectly play a role in, because if we were not competent for that, we wouldn't be competent to negotiate in the first place the DFT. Meaning there's a certain distribution of competence, of course, in the EU between member states and the EU. But one thing which is clear is that it's an EU matter when there's an interference, when national security activities interfere with privacy. And this is what is all about. Meaning what kind of safeguards and limitation are in place in the EU when our national security agencies need to access that. And there are common principles and common requirements that apply essentially under the ECHR. There's 50 years of case law of the ECHR on how to balance privacy and national security, and that is part of the exchange we are having with the US. When this will happen, and I will end with that, that's of course meaning that I don't have an answer to that. So when will the EU, the EA be designated as benefiting from that redress mechanism? We hope this will happen as soon as possible, and what is very clear is that our adequacy decision will not enter into force before this happens. We need it for it to become effective. Sorry, it was a long answer, but the questions were rightly so, touching upon quite complex issues.
No, thank you very much, Bruno. And actually, I'd come back to you, Joe. You heard Bruno. The EU seems quite optimistic in that sense on future EU-US data flows. What's your feeling? What's the UK government's feeling when it comes to US-UK data flows? Do you share this optimism? There was something announced 2 months ago. We haven't heard anything since. Are you working along the same timeline?
Well, hopefully it won't surprise you that if I say I share the same optimism and also realism that Bruno shares on behalf of the European Commission. We welcomed the EU-US agreement in principle earlier this year. It feels like a long time ago now, but that was an incredibly important breakthrough moment. And of course, a huge amount of thoughtful and robust work has gone into the design of the executive order and the Attorney General regulations. We've been involved in discussions with the United States interagency group since the day of Schrems 2 on what a possible solution could be, and we've had a healthy dialogue as well with the European Commission on these and many other issues. We are optimistic that there's certainly momentum, there's willingness, there are processes and discussions that need to take place between parties, and there are also stakeholders that need managing and processes that need to take place internally. Bruno touched on the internal EU procedure. We in the UK have our own process where we will need to draft our own adequacy decision. We will share our analysis with the Information Commissioner's Office, our independent data protection regulator, and then we will, at the appropriate moment, lay those regulations before the UK Parliament. It's a similar but different process to the EU's internal process. So there's more work to do, but we're optimistic. It's important we get this done. I should say, and a lot of the discussion has been on this transatlantic equation, so to speak. This is a global discussion, right? There are global developments and there are global trends. Asia is very busy. They are pursuing their own international arrangements and agreements. We need to find a way of delivering with what's in front of us, and the challenges that we hear time and time again. Organizations are saying we need a sustainable, scalable, durable data transfer mechanism for EU, UK, US, but we are also at risk of missing what is happening around the world, whether that's sub-Saharan Africa, the Middle East, Asia Pacific, and we have got to find a way of doing both, right? Delivering with what we've got and what we need to do in the short term, but also moving the conversation and moving the work to the global dimension. So one of the panelists, I think Barbara, mentioned the Global CBPR Forum Initiative, there's the OECD initiative. There are other fora and initiatives that we're also exploring, which give cause for optimism as well.
Thank you, Joe.
I can only agree. Meaning we very much focus now on question and answer on the EU-US, but meaning amongst our main partners in this conversation, we have Asian countries, Latin American countries, African countries, and I think you will see in the coming month many developments with those partners, bilaterally, but also in this sort of more plurilateral approach to data flows.
Thank you. I see a question over here.
Thank you very much. I just want to bring a bit of AI into this, if I could. If I understand correctly, with the GDPR, it's about the transfer of data between regions or so. We have an AI DV data visitation working group. How do we deal with when the data remains within the particular jurisdiction, but the algorithms come and interpret the data? Is there any framework for looking at that, legal framework for that, with regard to GDPR or other areas? Bruno, I'm just wondering if you have some thoughts about that.
I thought I had already sufficiently. I want also to give the floor to my other co-panelists, but very quickly, 2 points. First, when we look at transfer, we look, of course, at the protections that apply in the system to which the data is transferred. We don't look, of course, at a system which is identical to ours, but we look at the system in its globality and in its totality, and have to determine whether that system delivers a similar level of protection. Because when we adopt, for instance, an adequacy decision, it's quite a unique thing we do. We say, well, a third country can be assimilated to a member country of the EU, while of course that third country is not subject to the same rules. Assimilate, of course, to the extent data flows are concerned. And meaning amongst the elements we're looking at, there are elements in the GDPR that deal with the impact of the use of algorithm. I'm thinking, for instance, in particular of the rules on automated decision making. That when the use of algorithms can lead to certain decisions that have an impact on the rights of obligation of an individual. I don't know, in terms of loans, in terms of similar impacts on the right and obligation, significant impacts on the right and obligation, there are certain of rules that apply under the GDPR. Do we look at exactly the same rules in the foreign system? The answer is no. But we see also, for instance, under the AI OECD principles as endorsed by the G20, that there are common principles in terms of transparency, in terms of challengeability of certain decisions based on algorithms. So that's the type of sphere on which we work with our international partners.
Thank you. And maybe I'll just pass this question actually over here. When you know, just from a perspective of dealing with these issues also in practice, how do you do it? You mentioned the importance of standard setting almost more than for example rules. Is rules and regulations? Is there anything more that you'd like to add to that? The international standard setting as well, and the efforts that you're engaging with in this respect.
Well, from our perspective, we really tried to build a principle-based program internally. I mean, we monitor all the laws, the regulations, we update our policies to reflect it, but then in terms of how we train, how we talk to developers, how we build, we try to bring it back to more of a values-based, principle-based program. And we have 3 fundamental principles. We put privacy first, we innovate responsibly, and we safeguard fairness and trust. And those can work around the globe. And then underneath that, we have a really more of a detailed common control framework where it can go more into the weeds in terms of the controls we have to have in place to meet the regulations in each of the countries. But again, for the employees we're talking to, we try not to talk regulation. We try to make sure that we've reflected the regulations requirements into the programs we build and the controls. But as we're seeing perhaps divergence in some of the areas, it does create more complexity in terms of making sure that we're able to build things that are configurable, that are flexible for customers to be able to use, and that we then can make sure that we're keeping up to date and supporting ourselves.
Yeah, you brought in AI, and kind of we've acted there, we've progressed in a very similar fashion with data. We back in when data was high on the list, GDPR, we came out with a data commitment with, for us internally, it's kind of like an assurance framework which clearly established principles such as we will not sell data without the consent of the consumer. We will be transparent about the data use, and we will use it for what we ask them why we want that data in the first place, and he gives us the consent or not. We just come to introduce an AI assurance framework. It's again for us kind of taking the same route, and we look at it obviously, we're a commercial undertaking. We need to fight for the trust of our customers. We won't get customer loyalty, we won't get customers if they ultimately don't trust that they're getting what we're promising them, what they're expecting. Such an AI assurance framework, it's critically around transparency. You need to know as a consumer when you're facing an AI language-driven chat box as opposed to a real person. You need to know that. You need to know when a decision which is made has had an AI involvement. And I think even more important, well, you can only do what I say next. By knowing that there has been an AI involvement, you can challenge that and ask for explanation of why the outcome that came about looks the way it looks. That's how we deal about it. For us, the concern, again, it's similar as with data. If we end up with a proliferation of divergent rules, fragmented rules, which we have to comply each and everywhere, as a company who ultimately operates in, take away the 4 to 5 blacklisted countries in this world, like North Korea, Myanmar, everywhere else, we operate in the sense of we provide our services. And if in the end, each of these places require you sufficiently divergent kind of set of compliance activities, reporting and everything which goes around, that won't come without a price. That's all I'm saying. And that's where our interest lies in these discussions and in making sure, and we're applauding obviously all these developments, be it at the OECD level, the fact that in Asia there has been quite some progress in kind of agreeing rules along which data shall, in my wording, be free to exchange. That's never free in the Wild West sense. It's free within a clearly defined, delineated framework. All of that we welcome, applaud, and support.
I can, sure. I mean, I agree with most of what you said. I think in terms of looking at the AI ethics part of it, it's also just still evolving so quickly. When we talk about privacy, we have so many years in terms of where the regulations have been and common principles, I think. AI ethics, I think you have to expect that you're going to see companies continuing to evolve and update and change principles as we're learning more about it, as we're seeing new regulations come out. And I think one of the challenges there is, as we're talking about things like conformity assessments or reviews, we don't have, the standards that we have in terms of security and privacy. We don't have easy to test and demonstrate ISO standards or things. And so, again, I'm really hoping we see more developments there so that it's easier to have ways to demonstrate as a company that you're doing the right thing in an agreed upon manner. And I just don't think we're there yet. But otherwise, I think.
Yeah. Thank you very much, both of you, and maybe Bruno, the last question for you before you head off. We've just had the importance of standards, and you'd mentioned in your opening remarks the Commission is working on the OECD. Is there anything more concretely planned there that you can tell us today?
Well, what we have done in the OECD that has been mentioned by Joe and by others is that for the first time at international level, we have developed a set of principles that the like-minded countries of the OECD, always forget how many members there are of the OECD, but there's a significant number, maybe Joe knows it. 38.
Not that many. I think there's a few more countries in the world.
Well, yeah, but 38 like-minded democracies. Yeah. It's not bad. And those countries have, and by the way, at the OECD, there's also a possibility, and I think it will happen with this document that will be adopted in 2 weeks for partners of the OECD to intervene and support the document. So it's not only 38, and I think it will set the standard because those are principles in which again, like-minded democracies, even those who are not members of the OECD, will recognize themselves around things we have discussed. Proportionality, necessity, redress, oversight, a certain number of rules of the game. This is not about saying that government should never access data. Government should access data for very legitimate reasons, fight against crime, addressing national security threats and other public interests. But when they do this in certain systems, like ours, the ones of the OECD and others, we do this within a certain perimeter, with certain rules of the game. And that's what the OECD exercise is about. And it's not just me and Joe talking about it and saying how great it is. In 2 weeks at the Digital Ministerial in Spain, the OECD Digital Ministerial meeting in Spain, that document will be adopted. So let's also manage expectation. This is not a treaty, this is not a convention, this is not a binding document. But I think it's very significant that those countries have come together and recognized that this is an issue and that we deal with this issue in a similar way. It will help those regulators which are looking for standards, which when looking at a transfer from country X to country Y or Z, are asking themselves, okay, which are the common rules, common values, common principles these countries have or not. It will also help companies. Somebody has mentioned transfer impact assessment. So that's an example of, I would say, we talked about politicization or depoliticization. I think that's an example of the multilateralization dimension of this work on data flows, which, for the reason I think we all said, is very welcome.
Thank you very much, and thank you very much for joining the panel. All right, looking into the room again, I can see a question over there. Just here at the front.
Thank you very much. Yeah, this is a question for Bruno and Joe Jones, maybe. So
Yeah, Bruno has to go, but
oh, okay.
maybe.
I will be quick then. Are you considering to include sunset clause in the future adequacy decisions, which will be adopted by the Commission, as it is the one with the UK? And the second question for Joe Jones would be: Are you? I know that the Commission is closely watching your plans to reform the data protection framework. Are you considering anything that would derail from the GDPR? And are you concerned that you might be, let's say, in trouble maybe with the EU-UK adequacy decision? Thank you.
As I have to leave, I will answer very quickly and leave it to Joe. We will be very happy to answer for me. We could actually exchange the question because I know what Joe will answer to you. The UK is committed to keep the adequacy decision. So on my side, we adopted an adequacy decision with respect to the UK on the basis of a certain system. That system, we don't know yet because the UK government has tabled a bill, and by the way, it was from a previous government, and this government has said that it is considering this bill. Changes, meaning that adequacy decision we have adopted with respect to the UK, as any other adequacy decision, has to address the situation when where there could be changes to the system we have found adequate. So my answer will be as for any other adequacy decision. If the changes affect the level of protection we have found as adequate, that will have consequences because it will be a different system than the one we found adequate. Whether this will happen or not, Joe will tell you about, but certainly we have questions around, for instance, what will happen with the independence of the ICO, what will happen with requirements when it comes to international transfers, and these are things we are discussing with our UK colleagues, and we will of course very closely watch what happens during the process, including of course the very important parliamentary process. With that, thank you very much for your attention, and I guess see you soon in another venue.
Thank you very much, Bruno. Joe, I think he answered for you, but maybe you've got something to add.
Well, the miracle of international data transfers extends to its powers of ventriloquism as well. So Bruno is, of course, right. The UK is seized of the importance of retaining and maintaining EU adequacy. It's our view that it's perfectly possible to do that alongside operating a national data protection framework that is different to the GDPR. Now, of course, the devil's in the detail, and it'll be the nature of that difference. And so what is informing the UK government's policy thinking and the design of a future GDPR-type law in the UK is looking at and getting inspiration from other countries around the world, especially those other countries that have EU adequacy and what they do and why they do it. And speaking with Bruno and his team and others in the EU and Brussels on the GDPR, what it means, and some of our reflections and lessons learned. Now, a lot of people will say the GDPR is a relatively new law. Well, that might be so, but a lot has happened in the space of time that we've had it. And there are lessons learned. Some of those lessons have been forced upon us. The pandemic has made us think about how data can be used, misused, and abused in the context of sharing health data and sharing data on populations to keep the public safe. And of course, the war in Europe has forced us to think about these questions as well in another context. Now, it's right that we go through that process. Our political leadership and officials here in the government are taking a very transparent, consultative process. We have an overarching principle with the Commission and with many others that there'll be no surprises with the UK government's approach to these issues. But we are very much taking ideas, taking the best from the rest of the world and taking inspiration from Europe as to what could the next iteration of the GDPR be in a UK context.
Thank you, Joan. And would you hope that the next adequacy decision would not have a sunset clause like the current one?
Well, that would be my hope, yes. I think in this ever-changing, fast-developing, increasingly complex field, arbitrary, somewhat artificial deadlines don't help. I think they can create uncertainty. We saw that, of course, with Brexit, where we had a series of dates that felt like cliff edges. If things are not done in time, what does that mean? And of course, dates can help focus the minds. They can help marshal resources. But I think as an overarching principle, the approach that Bruno articulated, where we, the UK and the European Commission, look at what's happening around the world in adequate countries all the time. We monitor and we review and we look at developments from the perspective of thinking, are they still adequate? And also from the perspective of, oh, that might be an interesting idea. Maybe we should think about doing that ourselves. I don't think deadlines help with that.
All right. If there's no questions, there is one question in the room over there.
Good afternoon. Dominic Spada from the American University of Paris. I'm curious as to, you mentioned the welcoming of the GDPR in a sense of unifying regulation across Europe. If you feel these increasing regulations that keep popping up time and time again and promise to continue, if they will increase that fragmentation and if they're threatening to disrupt kind of the data flow processes that you deal with, both from the government perspective and also from the business perspective.
Sebastian, would you like to take this one?
I guess I'm the only non-government and non-business here in the panel, so
you bring an objective perspective.
Well, you're mentioning specifically developments in EU law, the recently proposed legislation under the data strategy, I guess, and whether that will lower the level of data protection in the EU. Is that the target of your question?
Not strictly lowering of protection, but whether it will disrupt or threatens to deunify or increase challenges and to compliance, not necessarily just within European regulations, but more globally for, we have panelists from global institutions that deal with not only European regulation, but also global regulation, and whether the increases of regulations are closing some of those gaps that can exist within regulation, or whether they're opening new ones as they're closing some, or kind of that balance.
Well, not necessarily data protection gaps, because that's different types of legislation. Of course, we'll see next year a new law being proposed by the Commission to harmonize administrative procedures applying to data protection complaints, for instance, and that's data protection specific. There are other laws that have other objectives, but also have a significant interplay with data protection, notably laws that deem to foster data sharing across the bloc, the Data Act, the Data Governance Act. Of course, you look at the joint opinions by regulators in the EU and their warnings that some of this may actually water down some of the safeguards that we have currently in the GDPR. And so the EU legislators in the process need to be aware of how that could harm the level of data protection across the EU. But I can only speak from an EU law perspective, because obviously, as I mentioned in the beginning, I am an EU lawyer. So in terms of other global efforts and how they impact, for instance, existing adequacy decisions that the Commission has issued since the Data Protection Directive, I would have to refer to other specialist voices. So.
I can jump in there in terms of, for us from a B2B perspective, the harmonization through the GDPR was incredibly helpful to be able to look at one requirement. And it is disruptive now, seeing things like what's happening in the United States. We're a strong supporter of privacy protections, but seeing the state-by-state approach where there might be a slightly different nuance in each one, as opposed to looking at a U.S. federal law, which is why we're supportive of that. And then in terms of seeing the regulations across APEC, I would say in general, we're seeing a lot of alignment in common principles and things with the GDPR. So that one's not as much of a concern, but it is becoming, I'd say, we're a larger company and we have, the ability to do all of this monitoring and to do all of these agreements and get it out while operationalizing it. I think for a small to medium company right now, it's really challenging until there's the interoperability and common standards and frameworks to be able to stay on top of it and keep your policies updated, keep the notifications updated, keep your contracts updated, and operationalize what you have to do behind the scenes at the same time. I think it is becoming a hurdle for the small and medium companies to comply.
Maybe an aspect I would like to add. We like to think rules, it's a little bit like standards. Imagine a world where you wouldn't have a unit of account to measure things like weight or length. It would make doing business of any type, maybe not even insurance in the first place, but also insurance, very difficult. You need to have kind of a structuring element. So that goes against those who think always big business is against rules or something like that. Well, there needs to be a structure in place, otherwise we don't even know what we're talking about. Another thing is what I referred to in my comments about the compliance complexity. If you have to deal with a myriad, 15,000 different weight measures, then it's just kind of, it slows down everything if you want to exchange on the basis of how weighty is this against that. It's useful when everybody works with kilograms and let me say that dumb and plumb. It's because then we know 5 is more than 3 and 7 is more than 5, and we know it is the case. It's not that this is only 7. What would be I don't know, another measure which kind of brings it down. So disruptive, it depends of how you mean disruptive. Disruptive is when you don't have anything that helps you kind of structure. Disruptive is if you have an overflow of structuring criteria, and it's, as always, it's about getting the right amount, the appropriate amount in place.
Thank you. And as we're nearly out of time, is there one last question from the floor? Yes, over there.
Yes, thank you. My name is Niklas Giesecke from Regional Court of Germany in Münster. And as the Commissioner and Bruno have left, maybe we can look a little in the future and what your hopes and expectations are, as there seems to be everything on the table with the executive order now. Do you really think that the adequacy decision that is coming up is something to rely on a long term, or are you already having nightmares about Schrems 3?
I think this is actually also a perfect closing question, so I'm going to just steal yours and make this one the last one. Barbara, if you'd like to start.
Sure. I'm hopeful that this is a long-lasting adequacy decision. I'm fairly confident there will be a challenge, and we will see it go through the court system again. I'm hopeful this one will last, but we will continue to offer standard contractual clauses and binding corporate rules for processors to make sure that we have other mechanisms as well as our transfer impact assessments and not rely solely on it. But we are committed to also remaining certified to the new framework once it's available.
Okay.
Well, we certainly hope that at the end, technical assessment, these are good, solid technical progress that is happening in our perspective. And we hope at the end of the day, technical assessments prevail. Because I know he isn't here anymore, but and he shot a little bit about my depoliticized things. What we mean by that is, if we have a technical assessment which is solidly and robustly established, let's not bring in political games which ultimately are driven by other agendas and break down good arrangements, good consensual solutions for those reasons.
And Sebastian, what
are
the chances of Schrems 3?
As per the chances of Schrems 3, we really don't know, because we still need to look at the adequacy decision. It is uncertain what the Court of Justice, if it is called upon to decide on the lawfulness of the decision, will say. What we do think is that the solution is not to turn into data sovereignty or localization at the EU level. That's not the solution, because in the digitized, globalized economy, data will flow, and it's not possible, in our view, to just keep that within the EU as a response or reaction to these tensions. Also, with regards to extraterritorial laws that would force companies within the EU to give access to foreign entities, which is also a concern that DPAs have expressed. So although we see many initiatives from EU regulators and governments and the EU itself to come up with certain initiatives that seem like sovereignty or localization initiatives, sort of certification of ICT providers according to schemes approved at the national level, for instance, giving a preference to local providers, coming up with new definitions of particularly sensitive data that shouldn't leave the continent. All of this seems very sovereignty, localization oriented, and we see this trend also going on the non-personal data sphere with DGA and the Data Act. And it is worrying because it seems like it's giving up on the hopes that we can arrange a standard of, through corporations like in the OECD process, of an acceptable level of government access to data that actually complies with democratic principles. And I don't think we should give up on that process, and it is possible through them to achieve a level in which we are comfortable to continue keeping the data flowing through with those countries.
Thank you. And last word to you, Joe. I guess there won't be a Schrems 3 in the UK, but what are the chances?
We have our own court. We have our own court system, and I don't doubt that we'll have challenges in those courts in the future, and I very much hope we'll win them. But I'm optimistic. I'm also excited because I think in future years, I suspect we won't be talking about Schrems 4, 5, and 6 because we've hit a critical mass of countries that are doing data adequacy or things very much like data adequacy. The last time of counting here in the UK, there were over 70 countries that do data adequacy technical assessments that are not the European Commission or the UK government. That is a huge increase from 5-10 years ago when it was just the European Commission doing data adequacy. And it will not be sustainable to be talking about Schrems 1 all the way to Schrems 10 in all those different countries, and to be speaking of unilateral and bilateral arrangements between the 70+ jurisdictions. So I'm excited because I think we've reached critical mass where we recognize the shortcomings, and we're going to have to come together to reach a more plurilateral, multilateral solution that is more sustainable.
Thank you very much. Those are some very hopeful words to end this panel on. I'd like to thank all of you for your attention and your questions, and our panelists, Angel from Zurich Insurance, Barbara from Workday, and Sebastião from Future Privacy Forum, of course Bruno had to go, and of course you, Joe, from the UK government. There's a little bit of time now, around 10 minutes, to go grab a coffee very quickly, and then we'll start back in this room here at 3:45 for the last session of the day around data privacy and future technologies, future-proofing regulatory and technical considerations. Thank you very much.
Hello. That sounds like it's working. So, hello, good afternoon, and welcome to today's panel on future technologies, data privacy, and digital services. My name is Patrick Grady. I'm a policy analyst at the Center for Data Innovation. For those that don't know, the center works at the intersection between data, technology, and society. So before I introduce my lovely panel today, I want to start by setting the scene a little bit, lighting the candles and setting the mood, maybe. It's easy to forget just how far we've come. Billions of users, internet users, including everybody in this room, is accessing search, media sharing, messaging, music, video sharing, all for free, because some of us click on an ad every now and then. Now, this has led to a business model that has boomed our digital economy, and it will continue to boom the future of the web. Nevertheless, users are concerned, rightly concerned, about the collection of data and the exposure to cybercrime. So, today we'll be talking about some of these risks. For example, if I'm able to use the buzzword of the day, metaverse-based technology. With emergent technologies comes emergent risks. Now, imagine you're wearing a headset and you're in a virtual application. Unlike our 2D world that we're familiar with, the content is completely ephemeral. What this means is where you look, your very gaze, all of this data can be tracked. I've completely lost my train of thought. Yes, all of this data can be tracked, right? So even your pupil dilation, they can say something about you, can say your sexuality, your preferences, your purchases. So with these new technologies comes new risks, and we need to be ready for this. Similarly with AR glasses, for instance. These devices can constantly record the public without any obvious means to consent. They also are able to completely track the movement of the user. Also, blockchain technology. There's some really cool things that blockchain technology can do. It can provide new solutions for payments and for sharing digital assets. But it's completely recorded and remains online. How does this fact collide with our principle of the right to be forgotten in the GDPR? So, this is the challenge, and I'd like now to introduce our lovely panel. So we have, oh man, if that locked, we are not unlocking it. So we have Leonardo Navaz, Director of EDPS. We have Marco Pancini, Privacy Policy Director at Meta. Monica Adamczyk, who joins us virtually, not quite in metaverse-grade technology, from the cybersecurity experts at Anisa. And Elise Hulick, who's Chief Privacy Officer at Intuit. Now, the way this works, a bit of housekeeping. I will give each of the panelists a moment for some introductory remarks. This is also the good moment to correct any of my mispronunciations. And then I'll direct some questions at them, and throughout the session, please feel free to interrupt each other. Audience members, if you raise your hand during the session, I'll try and catch that and integrate it into the discussion. And then at the end, we will have time for some bespoke audience questions. So without further ado, let's start with Leonardo.
Can you hear me well? Yeah? Okay, good afternoon, everyone. It's a pleasure to be here with you today. It's the late time in the conference, so I hope you can bear with us. I've received some speaking points from my team here, which look a little bit too technical for my taste. So I will try to be a little bit more sparkling, otherwise you will feel too tired now. So first, a few words about the EDPS, in case there is someone in the cyberspace who is connecting from Singapore or I don't know from where and is not familiar with us. So we are the Data Protection Authority of the EU institutions. That sounds like the EU Data Protection Authority, but such a thing doesn't exist yet. We are only the Data Protection Authority supervising the processing of personal data of the EU institutions and bodies. We are not supervising the processing of personal data in the member states. It is done by the national data protection authorities. However, we are competent of the supervision of very important bodies and agencies such as Eurojust or Europol, and therefore what we do in this particular field is particularly relevant. and we try to lead by example. Yesterday, we organized a conference with the data protection DPOs or in the area of criminal justice. And then we try to discuss about viable enforcement models in this system. So just to give you an example of the kind of challenges we do. So we supervise, like a data protection authority. We provide advice to the EU legislator. We issue opinions on any legislative proposal that has an impact on data protection. We participate in the European Data Protection Board as a member, and we provide the secretariat of the European Data Protection Board. So we make sure that they have the people and the resources necessary to do the work of this board. And this is what I would like to focus today, we are mandated by the legislation to closely monitoring technological developments. And we decided to go a bit further than that. And we, in our strategy for 2020-2024, with our supervisor, Wojciech Wieborowski, we decided that we would focus on forecast of new technologies. And we hired a group of people, a unit in our organization, which is called Technology and Privacy. And they have several activities, monitoring technologies and forecasting the evolution of technologies. And I would like to draw your attention to them. They are on our website. There are basically two. One is called Tech Sonar, that is supposed to look at technological trends that have potential to influence or to have an impact on the privacy of individuals. And then we have another thing which is called Tech Dispatch, which is regular publications where we explain in plain words for everybody the technology, the main features, and the risks and opportunities that we see for these technologies. So this is our contribution from the technological side for these emerging technologies. And we also have something that some of you may find interesting, is what we call the IPEN seminars. So this is an initiative where we put together privacy lawyers and engineers, and we talk about privacy engineering. And today, as we speak, we are having one of our seminars where we are talking about the state of the art on digital currencies, for example, because next year, as you probably know, we will have proposals for a digital euro, and the EDPS will have to advise the legislator on that. So today we put together people from the central banks, academics, and people from industry to talk about the different models and design solutions so we can anticipate a system which is as it should be, being European, so privacy friendly and privacy by design features. So I think this is enough as a matter of introduction, and look forward to the more interactive discussions later. Thank you.
Thank you very much, Leonardo. Marco.
I think it's working. Hi, thank you so much for having me. I'm feeling like the elephant in the room or the gatekeeper in the room. Depends on the possible definition, but like jokes apart, I'm very happy to be here to discuss with you the opportunities and the risk connected to the metaverse. But first, let me let me define what is the metaverse. So I think what is going to make the experience in the metaverse different from experience that we have today in using other technologies is the feeling of presence. This is going to be a defining feature of the metaverse that will also, in my opinion, characterize the way we are all going to deal with this new environment. It's just an evolution of the internet. Yes, it is. It's an evolution that is based on most of the technologies and the tools that we're using today to assess different services online, but will add this element of immersion. This element where we, in a certain sense, we are going to be in a sort of an embodied internet. The experience, we are going to live in the experience and not staring at it like it's happening today whenever we have a video conference call or we are playing on something online. And really this feeling of being the experience, to be present in this new environment will be what is defining the metaverse and every product that we are going to build in the metaverse and others also are going to build in the metaverse. Let me now focus on two other points. First one, how we're gonna live this experience and what are the tools that a company like Meta is building. And second, also enter a little bit more into the specific of the topic of the day and therefore the privacy implication in building a response in a responsible way the metaverse. So first, let's talk about the products, which is, I think, it's an important way also to frame the conversation about the risk and opportunities. So first, when we speak about the metaverse, we are talking about something that probably we're going to really experience in the full capacity in around 20 years. But the way that is going to lead to these set of opportunities is actually very interesting and is about developing tools that are both allowing us to have augmented reality experiences and also tools that will help us to have virtual reality experiences. I think we should not undermine the importance of start using some of the services that define the metaverse also through augmented reality tools or even 2D experiences. So first, because I think this will make sure that all of us can start to familiarize with the new way to socialize and live experience in terms of entertainment, work also with the tools based on the metaverse. And second, because I really think that there are incredible innovation that can be untapped thanks to augmented reality. That's why we launch some products, like for example the Ray-Ban Stories, and there will be more to come in this direction that are really looking at augmented reality as a way to start familiarizing with the metaverse. And in building this product, we are following the same responsible innovation principle that I will then describe also about our VR tools. But I want since now to say that these responsible innovation principles are guiding the way we are developing our ER products in order to make sure that first, bystanders can be informed if the user of the device is for example, taking a picture or taking a video. In the experience, we have created some specific LEDs that can give to bystanders information about what the user is doing about with his glasses or air glasses. That's probably not enough. That's why we work together with data protection authorities, the Italian one in particular, on an education campaign to explain both to users of the device and to bystanders about these features and how to be informed in a transparent way about these features works. In the future, augmented reality will really help us, for example, to being in the experience to receive information in real time that can help us to have an augmented experience. For example, imagine that we want to learn how to cook a specific, why not, Italian dish, and we don't know how to do it. We could receive instruction in real time while we are cooking, thanks to some widget or some objects that can appear in our site thanks to the glasses that we are using. But that's of course interesting, but let's imagine that the same opportunities can be untapped when we are receiving or giving a training on important matters like, you know, first help practitioners in the medical field or in the education field. when we transition into the VR, we can even see how this experience can become even richer. And here really we start to play the social element that we believe is going to be at the core of the development of the metaverse. The social element is referring to the feeling of being in the experience, being totally immersed in the experience, and have in the moment that we are living the experience, for example, if we are interacting with another person in the metaverse, the sense of presence, the feeling of presence. And this is going to be probably one of the biggest innovation that is going to come with the metaverse. That requires, in the context of VR tools, of a lot of very sophisticated technologies that can that has to be developed, and of course also very important consequences from a privacy point of view. So here I would like to quickly go through the principles that are guiding us in building a responsible metaverse. So we developed this principle as also I would say part of the development of self-consciousness at Meta on building products that has to take in consideration privacy by the moment that we are designing them, and are guiding everything we are doing in terms of product development, are called the innovation principle, and they really go to the core of establishing a trusted relationship with our users. First, our principle says never surprise people. And this is something that we are really trying to implement. If you tried, for example, the setup process on Oculus, our VR device, you saw how we are really driving the user through all the setup experience step by step, guiding the users to make informed choice for every data collection that is done by the device. And that's the goal, is really to guiding the user through the setup experience and through the experience in these new devices, to make sure that there is not this creepy moment that things are happening without users really understanding why. Second, provide controls that matters. That's for example, once again, if you tried these tools, and then at the end of my presentation I will give you some hints on how this can happen, even in these days in Brussels, you saw that all the main features of these devices are off by default, because we want users to make sure that we want to make sure that users make informed choice in a very transparent way on activating every and each of the devices, of the features of the devices. Third is consider everyone. We want to build these tools for everyone, not for just an elite or a majority or a minority of people that can afford to pay for them. Still, the cost of the technology is very high. When you see, for example, the cost of the devices that are now on the market from Meta, the price looks high, but I can tell you that this is exactly what is the cost of the development and deployment of the technology on our side. And our goal is really to try to drive these prices down in order to maximize the opportunities for everyone. And finally, we want to put people first. We are building these tools to experience the metaverse, not as a substitution of the reality or creating a virtual reality that should take the place of our own reality. We want to build the metaverse in a way where users are very clear when is in the virtual experience and when is in the real experience, and it's a human-centric approach to this technology. Finally, I promised you to give you some information how to use this device. We are in these days running an initiative called the Meta Innovation House. Is here in Brussels near Schumann. If you search online Meta Innovation House, you will see that there are a lot of events happening in the coming days, and I strongly encourage all of you to, if you are interested, to try the device, to register. In particular, there is one event next Thursday where we're gonna discuss more in details the privacy element that today we can touch only like in the limited time that we have in this panel, but we're going to really deep dive in this element with experts. So I encourage all of you to register. If you have problems, don't worry, write to me. Of course, there is a lot of requests, and I will try to do my best to get you in. And it's just my name, surname @meta.com. Thank you.
Thank you very much, Marco. And it was an important point about the diversity of products. I don't know if anyone caught the news last night from Neuralink, which is a company of Elon Musk. And they announced that within 6 months they'll be trying brain chip interfaces on human beings. Now, I know we're meant to be on Mars paying $8 a month for Twitter, but this prediction is a bit scary. But in the future, you might be able to bypass virtual reality headsets altogether. Monica, you should be able to see Monica on these two screens. Just give me a little nod to know that's happening. Cool. So, Monica, far away.
Thank you very much. First of all, I'd like to welcome everybody from Athens in Greece, where basically ENISA is located. ENISA is the EU agency dedicated to achieving a high common level of cybersecurity across Europe. And it has, in addition to our cybersecurity mandate, to support member states, to support operators of different services, to support citizens of EU. We also have a limited mandate in supporting also security of personal data. And for many years, we have been working on development on different type of recommendations, how to, for example, engineer data protection principles, how to implement such concepts as data protection or privacy by design and by default. I also can mention very quickly that we have a pleasure to actually cooperate with EDPS. We just signed a memorandum of understanding literally yesterday, and we are looking forward to our cooperation further with EDPS. We also occasionally support European Data Protection Board. Because I'm a technical and cybersecurity expert, I'd like to quickly talk about things that still bother many people. We rely on many technologies. We rely on tools that help with our daily life, that we use on regular basis at work, that support things like our health, our travel. And unfortunately, I think that despite many declarations from many different organizations, and I'm not pointing fingers at anybody here by any means, people still feel very powerless when it comes to what they feel unauthorized use of their personal data. And I can take as an example, as a very generic example, basically use of artificial intelligence, that everybody knows that for good AI systems to function well, there is a need for a huge amount of data. Data that in many cases, in many use case scenarios, requires, it has to be personal data. The problem is that this data is usually acquired from different sources, from different services, to which people contribute their own personal information, not being fully aware of the fact that what they provide for the benefit of maybe their friends, for the benefit of even strangers, can be used for completely different uses and by large number of different businesses and other entities. And the challenge exists that we cannot stop doing this, because if even for some reason we decide that, okay, from tomorrow everybody stops using social media, we stop shopping online, as I mentioned, the use of digital information is basically now present everywhere. We cannot be born without having our information being registered. We cannot go to school, we cannot go to university, we cannot get employed, deal with public administration, because no one uses anymore any paper documentation, and even the old records are being digitized. So effectively, we live in a world where data is the most important commodity. And without this commodity, modern economy cannot function. So we need to find a way how to basically find a solution, how to solve the problem that we can share the data, that the information can be used, but at the same time not to give everybody this kind of feeling of hopelessness that no matter what we do, we have no control over who knows what about each one of us. So there are many ways to approach this. There are legal solutions, of which I just very briefly mentioned because I'm not a lawyer. Obviously, everybody knows about GDPR, which has been in force for 6 years, and the implementation has passed actually 6 years ago. 4 years ago. I'm sorry, 4 years ago. It was 2019. We know about upcoming AI Act regulation, which intends to regulate AI systems, but using a risk-based approach. So basically, trying to address those systems and control how they function, how they operate, assuming that they represent a high risk to individuals and to the society and to different social impacts. There's of course some other acts. For example, Data Act has been recently passed by the European Union, which its purpose is harmonized rules on fair access to use and to use of data. However, the best legal solution don't always work because they need to have an implementation. And when it comes to technical aspects of ensuring correct use of personal data and minimizing the risk and negative impacts, regardless of the advancement of the technology, whether we are dealing with what I would call right now, very traditional, old systems, legacy systems, or we're talking about something as advanced as augmented reality, or perhaps even what Patrick has mentioned is, implantation of a chip in our brains. We have to start from some basics, and the basics basically are make sure that you have your privacy concept as a design, privacy as design, and privacy as default. It is surprisingly that despite the fact that this principle has been known for more than 20 years, if I remember correctly, Anne Kavokian has first published her privacy by design principles in 1995, so that's been like 27 years. We still constantly face systems and applications where we are being presented with pre-selected options, which prompt us to accept consent for processing of any data for any purpose for now and forever. And we are basically, as individuals, especially those who are not technical people, basically feeling powerless in this situation. So I would say that the very first rule that needs to be really respected and strongly implemented is that before any business initiative is being thought as a new concept, as a new technology, as a new solution, a very principal question has to be asked. Can we even do this? Should we even do this? Does this really going to impact our, privacy? Does this going to affect people? And if yes, what can we do to minimize those risks? What can we do to ensure that people feel secure and they feel that they can trust provider of a given solution? On a higher technical level, there's more and more technologies right now being developed that actually allow to process personal data in such a way that it doesn't provide a full access to this data to businesses. Examples of such techniques are, for example, data encryption in transit and REST, Such techniques like AI, generated synthetic data that can be used, for example, for training the machine learning algorithms. Different types of encrypted analysis, of which an example could be homomorphic encryption, or federated type of analysis or learning, where different types of data remain in different subsystems and are not being basically shared on a wide basis with everybody. And while some of these techniques are still being in, I would say, experimental phases, there are already commercial solutions. If somebody would like to learn more about how they could be used to implement data protection principles, I would encourage to go to ENISA website, which is basically enisa.europa.eu, and you can look up our publications, our recommendations. All these guidelines is available to anybody free of charge for download and can be used for implementing different type of data protection principles and systems that are privacy compliant. So that's it from me for the beginning. Thank you very much.
Thank you very much, Monica. And exactly as you say, trust is super important. Sometimes, I don't know if you've heard the same thing, you get a little pop-up from a product and it will say, do you want to send this report? And depending on the company, you don't really mind your data being sent back to improve the product. Similarly, if you're at a hospital and you just had a CT scan and they say, well, we might use this to train a machine learning system to recognize and diagnose future patients, you might not mind sharing that data, but it's obviously, it has to be upfront, has to be informed, and yeah, there has to be trust between the two bodies. So, best till last. Elise, please take it away.
Sure. Hi, everyone. I have to say, when this topic surfaced, I got very excited about it because I think I hope that the rest of the room agrees. There's a lot of optimism here because we can actually work on this together. This is all about technology that is kind of here now, but not yet. And I would even say things like, we've spent a lot of time today talking about AI. I think we're sort of just scratching the surface of what AI might be able to do. And so we have the right audience, we have the right stakeholders, and there's no reason why this can't go well. I can't speak for putting a brain chip in, like I'm not about that. I'm just gonna say personally, no brain chips for me. But maybe someone will change my mind down the road. One of the things that I get excited about when I think about emerging technologies, there are certainly super cool things I can do with a virtual headset and visit places and see art and do new things. But a lot of what drives the work that we do at Intuit is how can we take the technological base of those different types of things and put them into useful tools and services to promote and expand opportunities, particularly for small businesses. If you're not familiar, I hope you are, but Intuit's got a very long history with working with small businesses, small entities. We have 100 million customers worldwide, very strong presence in Europe. We've been here for many years. And so a lot of times you'll hear, oh, my mother's business uses QuickBooks, or oh, my cousin's store that she owns uses MailChimp, and all these are some of our core flagship products under the Intuit umbrella. And when we think about that, it's something that I think I would say we have a very strong passion about. We want to drive their success. When we look at opportunities before small businesses and challenges, a lot of time it comes down to lack of time, lack of money, or lack of awareness about both. And this can be down to businesses, we're talking about maybe 4 or 5 people, a self-employed individual. It's the bakery down the street that's using our software to manage their books and pay their people. It's the one woman who had a passion for fashion and opened a boutique. These are people who day to day need to be able to focus on the thing that they're passionate about, their tools, their products, their service that they're using to engage with the world. And they need to be able to stay competitive, stay engaged, and they should have the opportunity to be just as competitive as any big player in this space. So we think a lot about how there are smart ways to let them benefit from the information that they have and have products and services that let them have visibility into things like their cash flow, an understanding of how they're spending their time day to day, what kind of resources they're using. I've got statistics because I feel like everyone brings statistics to these things, but I would say, you know, a recent study from the ONS said that about 60% of small businesses fail within the first 3 years. And in 2020 alone, about 90% of those failures could be attributed in some way to a lack of awareness about cash flow or cash flow problems. And so when I think about the promises of these new technologies, what can we do to help them get access to these technologies in a safe and responsible way so that they can have a better understanding of their business, right? And it can be something just as simple as receipt capture. You know, a tool that would help scan and hold on to different receipts and collate them and process them and put them in order so that when the time comes to do reporting taxes, otherwise, you have an understanding of where your money's going, how it's being spent, what's happening there. It sounds very basic, but I would argue that if we are able to responsibly help these businesses leverage these types of technologies and understand the data that they have that's flowing through them, then that will accelerate their opportunities. That will keep them running. We don't want businesses to just survive and not go down in that first 3 years. We want them to thrive. We want them to grow. We want them to be as meaningfully engaged in commerce as any other player. And I think one of the things that I like very much about the EU approach is being centered in the GDPR, being centered in things like privacy by design, getting a point where I think, you know, if you weren't aware of data and its power, you know, the GDPR basically kind of knocked the world on its head a little bit and said, hey, pay attention to this. This matters. I see a lot of benefit in my role as Chief Privacy Officer as a risk management tool. Let's just say it out loud. Obviously, it's really important to stay on top of risk. But there are also commercial benefits at the end of the day. It can be a win-win if you are responsible from the start. And I don't say that lightly. To do privacy by design well, yes, there is a documentation component. There is, you know, a governance component. We had a prior panelist talk about how the role of privacy officer is really sort of morphing and becoming much more governance-oriented. But there's also a cultural component. It is getting into the minds of the people building the products and services and helping them right from the start understand that the data that they're handling is as important as if it were their own. And if you can get in that mindset and you can get it, then you start to see the possibilities that some of these new technologies will open up. So I tend to look at this as an opportunity, but I see the role that a lot of us will be playing along the way. You do need strong, consistent, valid regulation. There's no way to do this without guidance from the regulatory community. You need information from the public. You need the view of public society. You need to understand what individual consumers who are going to be engaging with these small businesses that we're trying to support, what their expectations will be. Otherwise, the products and services that will be offered to those people will be either not beneficial, not commercially viable, or worse, risky. You also need industry. You need the voice of industry. You need to have a perspective of what are the operational challenges behind implementing something one way or another. And I think if we can approach this more as kind of a team sport, where we are going to just get together and work on this, and it's not that your view is better than mine or my view is better than yours. It's about trying to find a way to make this technology accessible to as many people as possible, understandable and not scary, right? There are things about this technology that can be very scary. I think you opened up with quite a few of them. You know, it doesn't have to be that way. It can be that way if it is unchecked, if it is not governed appropriately, if it's not constructed and assembled in a thoughtful way. And so when I think about sort of what we're trying to do with this panel, which is explore some of the angles that come from, you know, how can regulation emerge and technology emerge at the same time and have the two coexist, I tend to see a lot of promise there. So I'm going to stop because I could go on, but we've got more.
Yes, thank you very much. One thing you said that just stuck out to me probably was 90% of businesses went out of business because of they didn't have oversight of the cash flow. How is that not 100%?
Well, there's always something, right? Isn't there a margin of error? And you'll have to talk to the ONS. They're the ones who.
That's, who are the 10%? Okay, right. So now we're already in the last sort of 25 minutes. So please, if you do have any questions, just raise a hand and we can go straight to some audience questions. But in the meantime, the expected benefits and feared risks of emerging technologies is often vague or ambiguous. How can we be more precise when assessing these technologies? And for example, we've heard privacy for design today multiple times, but how can we be more concrete about when discussing these technologies and their risks? Let's start with Monica.
I am not 100% convinced that those benefits and the risks are very, I would say, fuzzy. They are if no due effort is done to assess the risk. And the reason why this is important to do what, for example, in GDPR is called data protection impact assessment, which assesses the risk, of course, from the perspective of a data subject, or if you could, you could call it also, generic way, risk management, risk assessment. This is what is absolutely necessary to be done. And this has to be done through the entire life cycle of any solution that is to use data, personal data. Initial impact assessment needs to be done in the very beginning, just to, as I mentioned before, just to even see, should we even do this? Should we even consider such a solution? And then on ongoing basis, a risk assessment or an impact assessment when it comes to data subject, to individual personal data, has to be done. And then based on identified risks and possible risk protection measures, basically ways of minimize that impact, ways of minimize negative consequences, appropriate controls needs to be implemented. If this approach is adopted and if this is being on continuous basis done while the system is being designed, implemented, and then operates, because risk can materialize, but it can also change, depending also on the stage of such system, can be different risk. We should be able to, maybe not 100% guarantee, because in such situation it's never 100% guarantee, but at least significantly minimize the risks and ensure that such a system not only provides a business functionality that is intended, but also ensures adequate level of data protection and also of security. So at least that would be my position to your question.
No, it's a very good example with the GDPR risk assessments, as you say. I want to move to another question now. Leonardo, I'm just checking now if there's still no question in the room. How can existing or upcoming pieces of legislation enable the benefits of emerging technology whilst adequately addressing the risks? So a sort of sub-question in there is, will GDPR adequately assess the risks?
Thank you. As I did with my introductory speech, I'm going to deviate from whatever they brought to me. And it's too late, really, to go to scripted messages. So I would like to highlight that there is a huge misunderstanding about data protection, in particular outside the European Union, because data protection is not only about protecting personal data, it's also about making it possible the free flow of personal data. The beginning of this discipline that I witnessed myself when I joined the European Commission on the Data Protection Unit in 1999 was one of the freedoms of the single market of the European communities at the time. So we wanted to achieve that data could flow freely in the European Union. And in order to do that, it was necessary to agree on minimum protection in all member states. So there could be mutual trust about the processing of personal data. So from this moment on, 20, 25 years ago, the European Union has been investing a lot of time and efforts to make legislation, to pass legislation that try to achieve both objectives. So the data is protected and the data can flow. And it is, I think, a historical moment about this became in 2016 when Giovanni Buttarelli was appointed supervisor. And then one day he came to the management meeting where I was sitting, and then he said, I'm going to go to Silicon Valley and I'm going to meet with Tim Cook. And I said, Giovanni, you shouldn't do that. I mean, this is an American company. They represent business. And then he said, no. I want to tell Tim Cook himself that this is important, that data protection is something that we have to be serious about. And off he went. And he went to the headquarters and he spoke to Tim Cook. And then back in 2018, we organized a huge international conference where Tim Cook came. And then by that time, Giovanni Buttarelli was very sick. He passed away a few months later. And then he, in a totally historical speech, he advocated for serious data protection in serious business. And he titled his speech, Choose Humanity. And I must say that Giovanni passed away 3 years ago. And it is the response we have seen to all these efforts is very disappointing. It's very disappointing. Because we all continue to see that the technology that is being deployed is not sufficiently secure and data protection is not taken seriously as it should. Myself, this week, I'm receiving lots of emails where I've been told that I've registered in many websites because I've been the subject of a data breach somewhere, and someone is registering me in all kind of hotels and platforms and things like that. I don't even have the time now to go and unsubscribe myself from all these places. And I don't have a clue where the data breach comes from, because I think I've been subject to several data breaches over the last weeks. So the technology we are deploying is simply not secure. This is embarrassing. So if we are going to go now and have a leap to a new metaverse or to a new artificial intelligence system, and we go like this, gentlemen from industry, we are going to massively fail. This is not sustainable. We have to take privacy by design and privacy by default absolutely seriously, and we have to invest on this huge amount of money. I don't know if you know that in the European Union, we have decided that our leaders have decided that the famous 10%, so we will be investing 10% of our budgets in the next few years to make our systems secure, because we are so exposed to cybersecurity attacks that we have decided we will have to invest up to 10% of all our money in securing our systems. And of course, cybersecurity means also data protection. So obviously this is good news for an institution like mine, but it only shows the big problem we all have. And I don't think business leaders and political leaders are fully aware of the situation we are at the moment. And I think Giovanni Buttarelli already said it some years ago, and I can only repeat it. I would like to call for an approach like this, like the civil aviation sector. We have to put safety of the passenger in front of every other consideration. For people to go and to the planes, people need to be safe. For people to go to the internet, to the metaverse, to wherever they want to go, they need to feel completely safe. And every time that we have an accident, we have to learn from the accident, implement the lessons learned from the accident, and move on. And this is what the data breach notifications of the GDPR are supposed to be about. That is, every time that there is a data breach, lessons are drawn up and we get improvement. But this is not being done seriously. So what are we doing in terms of privacy by design, privacy by default? Very little. Very little. We need to do much more. And the sooner we change the mindset, we will start achieving the objective. We all want to have more data available for business for the benefit of everybody. But if we don't do that, unfortunately, we will end up with the scenarios that will not work, and we will have to start talking about data sovereignty. We will have to start about data staying in Europe. Then we will have to start talking about data not leaving the EU institutions and things like that, because the system will not be secure. So I think this is my message for you today, totally out of the script. Please, when you talk to your leaders, when you talk to your people, let them know that this is a high time that data protection and cybersecurity become central in the strategy of the company. If this is not done, then we know what will happen. And then, of course, people will be saying, well, data protection is so bad, and then create so much obstacles for business, blah, 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 blah. No, data protection is both about protecting the data and about allowing a free flow of data for the benefit of people and businesses. Thank you.
Thank you very much, Leonardo. And the advice your friend gave to Tim Cook, I'm sure it wasn't so appreciated by Meta and Google. Undercut the ad business overnight. Marco, so since we have you here, I think we should focus on the metaverse. I want to dig into one of these concepts that we've been using a few times, privacy by design. Can you paint a picture of what that would look like in the Horizon worlds, for instance, and then how you see that evolving if it gets bigger?
It's a really pleasure to build on this very important point, because we more than ever believe that if we can not build services that are based on a trusted relationship with the users, we're going to fail. And since this is an existential move that Meta is doing in building the metaverse, doing this without building trust is going to be impossible. That's why when we talk about our approach to privacy and the metaverse, for example, we are really looking at minimizing the amount of data that we are using. We are looking at enabling privacy protective data uses, and also we are looking in giving users transparency control. Let me give you a concrete example. So first I say that, as I said before, all the different features are off by default. And users have to activate these features only after they are clearly informed about how this feature works and what are the consequences for their data. Second, when we talk about minimizing the data and we described about the feeling of presence that the metaverse gives, the incredible number of data that are generated by the once again, the continuous exchange between avatars in the metaverse are, of course, not needed to be sent back to our servers. The ephemerality of the metaverse is a great opportunity for data minimization in order to make sure that back to the servers comes back only the data that are essential to the functioning of the machine. For example, the machine, in order to work, needs to also collect some data, for example, the eye tracking. The cameras that collect this data, so the image of the eye, don't send the information and the data back to our server. They keep them on the device, and what they send back to the servers is just an algorithmic analysis of the data collected that makes possible the machine to work. This is an important example to show, on one side, the use of the best of the technology to minimize the data collection. On the other side, the transformation of the data that are personal, like the image of the eye, into a pure algorithmic sequence of numbers that just allow the machine to work. Going back to the point raised, and I humbly say that I tried to follow Mr. Buttarelli's advice since the beginning. I started my job at first at Google and now at Meta. I remember the first trip I made when I joined Google now 15 years ago was to meet with Giovanni and ask Giovanni advice, and he gave me very important advice that I will keep always with me. I think that the industry has made important steps in the direction of interiorizing the lesson of important, I would say, important historical figure for our sector, like Giovanni. And what we are seeing in the product, I really encourage all of you to try the product that we are developing to enter into the metaverse, is the result of this interiorization, of this process that are bringing us to really build the products that have privacy at the core of their essence.
Thank you very much, Marco. I'm told we have a question.
Yeah, hi. This was partly already answered right now, what I wanted to ask. But basically, the way I understand this with the metaverse is, and correct me if I'm wrong, because I'm a completely layman here. I don't even know what your product is, despite of being a kind of a live cookbook, which you explained before. But my question is, so everything is turned off by default, and I have to opt into everything. Does this mean everything, like sharing my data with third parties, profiling me in every way? So this is all turned off. Who would opt in to this, like voluntarily? And if this, so basically the product now is not user attention anymore, which it is with Facebook, but now you are actually selling the device. Is that how I understand your business model here with the metaverse?
So let me unpack these because there are a few questions in your question. So first, what we need to make a difference between the services that user can use in the metaverse and the device that can allow you to enter into the metaverse. The devices will be based on two different kind of technologies: augmented reality, so the example of the cookbook, and virtual reality. The virtual reality devices, like for example Oculus or Quest Pro, in relation to the latest that we are launching, will allow users that are using the device to enter into a environment immersive experience based on internet technologies. In this virtual experience, users will be able to perform different actions, and therefore the device will help and empower the user to perform these actions. For example, play a game, for example, enjoy a piece of content, for example, work in a collaborative way with colleagues that are based in different locations. Today, we are using tools like Zoom, I'm sure more like any other video conference platforms of your choice, and you have the experience that you have is a 2D experience. In the metaverse, when you have the device, you can meet with colleagues in different locations and have a 3D experience very similar to the one that I'm having now, in being here with Elise and Patrick and everyone, and with you in discussing together. That's like to give you an example. In order to do that, you need to activate a series of features. For example, I described before the eye tracking one. Why the eye tracking? Because now I turn my head, I'm looking at you. I turn my head in this other direction, I'm looking at the door. In the metaverse, if you want to give this sense of presence to the person that is talking to you, you need to provide the same functionality. So when I'm turning my head in my device, in my room, the person that is using a device, is in the virtual room together with me, will see me turning my head, moving my eyes, and doing all this movement. This is empowered thanks to features that users has to activate in order to make them happen. Of course, you assume that the users will activate them because they want to use the device, for sure. But before this is happening, we want to make sure that the user understands how the technology works and what data we are collecting. Finally, on the business models, which I think is underlining your questions. I think there will be different business models in the metaverse. For example, users will be able to buy different NFTs or virtual items in the metaverse, to dress their avatars, to make their virtual house more beautiful, or for example, to try a specific experience, let's say buy a ticket to go to a concert or to watch a movie. So there will be different models based on virtual goods. There will be models based on creators' content. I think it's a great opportunity for Europe, and the Commission pointed this out in recent communication, how the opportunity is for culture industry to build nice and compelling experiences for the metaverse, both for education and entertainment. And finally, why not also there will be the possibility to use advertising-based models. We believe that in order to build these advertising-based models, it will be extremely important that the user will have very clear what kind of advertising is presented to them and how to control in a precise way the advertising that is proposed to them, and why not also select or not content of their liking. I'll give you an example of advertising. Let's say that you like a specific kind of games, sport games, and a developer is developing a new, very interesting sport game. Maybe it can be interesting for companies like Meta or the companies active in the metaverse to suggest users that there is this other opportunity. That's of course all to be built together, but in building this, once again, the principle that I described before will be at the core of everything we are doing, and we hope that also the core of other companies that are investing in the metaverse, because the metaverse will be not about one company. The metaverse, in our vision, should be open to everyone who is interested in investing in these new technologies.
Thank you, Marco, and thank you for the question. We have another one.
Yeah. Hi. My name is Manuel. I'm from Scania, Sweden. I'm very new to data protection, so my question may not be proper. But like a common person, I want to really ask, because these technologies are getting developed. Even before coming to this data protection, I'm just 10 months in this area. I was thinking that if I do not accept the cookies, I do not get any info. The website will not get loaded at all. Okay, I just say accept it. So when you say that you disable all the features, okay, people like me, 10 months before, okay, and who are there? Now I understand, okay, I need to select allow necessary cookies. They will enable everything because to use the product without knowing how their data is going to be used, or they have no knowledge of the privacy. Okay, and then we always see that the big celebrated tech companies, recently I was reading, WhatsApp, millions of data got leaked and available in the dark web for sale. Giovanni went and spoke to Tim Cook. Who is going to talk to Elon Musk? Who is going to talk to Sundar Pichai? Who is going to talk to Mark Zuckerberg and convince them? Why the government are in the first place not stopping these big companies to become bigger than the democracy and bigger than the government? Stop them, put them in prison or whatever, like that. Stop it so that you protect, because we trusted, we voted the government. They need to protect people like me, common man, who do not know anything about data protection, articles or anything. So I'm sorry, I need to ask this just like not as a privacy person, from the person who is standing outside of this conference.
Thank you. I was completely with you until you went lock them up, but no, so I take your point. It doesn't seem like much of a choice if you cannot access any of the features unless you opt in. That doesn't seem like much of a choice. We all share the same frustration with you end up pressing accept. I don't know if anyone on the panel wanted to respond to the comment.
Let me try, without talking about putting anyone in jail just yet. So when I think about the kind of comments Monica and my other panelists have been raising about privacy by design, central to that, there's an educational component, right? To be responsible stewards of data and then to be entrusted with it and use it to create products and services that candidly, we will commercially benefit from, our customers will commercially benefit from. You do have to deeply understand what you're doing with the data, and that includes the technology that you overlay on it before you begin to even pick up the pencil to do something. And then you have to think about where that technology is going to be applied. And I do think that there's significant room, and I think the partnership with the regulatory community the government, all in sort of making industry smarter about technology, even so that they can make an understanding of, this is a technology that I think would be viable for my own company or circumstance, and this is how it functions. If I don't know how it functions, I just know that there's this cool thing out there and it's the metaverse, and I'm like, I want to do the metaverse, right? Like, what does that even mean, right? Like, you need to understand the why behind it, and that's why I keep coming back to things like privacy by design, because you have to position it from the viewpoint of the individual. At the end of the day, you are going to be impacting people. If you impact people, chances are the reason you're impacting them is because of the data and the technology. And if you can't center the design around looking at that build from their perspective from day one, and to Monica's point, when that product evolves and changes, come back and look again. And you come back. You're never done with privacy by design. Privacy by design is not an exercise where you can kind of fill out a spreadsheet and be like, I did it. You know, like, there's work involved behind it. And I think there's got to be different avenues for conveying that information to the people who have that technology in their hands. And like I said, I think there's a very strong role to play from the data protection community, the regulatory community, in convening the right stakeholders to help explain things like, how does the metaverse work? What are the security implications from making this choice versus that one? And making it much more widely available than any one company or industry can do. But I also think industry has a role in it, in partnering with the government, these other parties, and giving visibility into what they're doing and why. And I think that's the sweet spot. I don't know that we're there, but that's where I think we should go.
Thank you very much. Thank you for the question. And if you did want to learn about the metaverse, there's an
Can I add something, Patrick? Can I add something to this?
Yeah, sure. Sorry. Are you there? Oh, that really
Okay,
confused
so
me.
I very much
Okay.
agree what was
What was in
just said right now, but I just wanted to also add some additional things. So, in addition of the education of the industry, which I very much agree, it is absolutely necessary. I think that one of the challenges exists that we don't teach, and in current times, it has to be from the very beginning, from the youngest age, what it means to have a responsible and secure and protecting us behavior online, on internet. I mean, we teach our smallest children, when you cross a street, to look right, to look left, depending on, you know, which country you live and which side of you drive. But we hand them, you know, when they are, you know, 3 years old, a phone, a tablet, and say, you know, play. I was a lecturer at one of the universities in Warsaw when I lived in Warsaw for a few years, teaching the principle of cybersecurity and data protection. And people who were 20, you know, early 20s, still didn't understand what it means. And the problem is that I agree with the person who asked the question that obviously they need to be protected as an individual, but they also need to have a certain amount of knowledge, of basic knowledge, to know that, first of all, it's not a good idea to accept all, even if it's highlighted, pre-selected, and it is actually good to give up on certain things if you have doubts and if you think that your privacy, your information is endangered. I mean, I know that this is a challenge because everybody just wants to click and forget about this. But I would encourage you, think twice. Try and see, maybe actual things will work for you, even when you won't accept all the cookies. I mean, the simplest thing that happens. And then if you absolutely have to use something, and then still you cannot use it because you don't accept all the cookies, then think maybe you can find an alternative solution. So the education of the awareness raising of everybody from the youngest age it's also lacking. And this is also why most of the people think that GDPR is only about forbidding to use personal data, which, as Leonardo has said, it's not true, and that's correct. And in many cases, when there's absolutely no issue of protecting personal data, people just use the GDPR as an argument that you can do something. So I think it's a situation where everybody has to work together and everybody needs to have a certain level of education that you need basically to have it from as early as possible.
Thank you very much, Monica. I want to apologize to the gentleman I gave an encouraging nod to. I think we will close the panel now, unless we want to take one more question. Okay, sure.
So my name is Karel. I'm a student in political sciences, and I had a question about the metaverse. So if I want to buy NFTs on the metaverse, do I need to buy it with the DM or can I buy it with the euro?
That's for you.
I think it depends on where, like on the platform where you're buying, like.
Cannot we buy NFTs on? I mean, what you said about the avatar on the metaverse directly?
Just to give you an example, recently we launched on Instagram the possibility to transform some of your pictures in NFTs, and my understanding is that this is possible, so to pay in euro. If this is not the case, please come back to me and I will apologize.
Okay, well, I now see another question, so are we going to make it that the last one? It was such a quick answer.
Yeah, I tried to keep it short. Thank you. Bertolt Schilling from Concilius Europe. So we've been talking all day about the GDPR, and I think in 2018 it was hailed as a success. But now, especially outside of Europe, it's mostly known for the cookie banners. And often the options are presented in a way that the easiest option is to just click on agree. And I mean, it's just human nature. Nobody wants to go through 5 pages and click on the preferences. Nobody reads 120 pages of terms and conditions. And it's been addressed in the Digital Service Act, especially the Parliament introduced some terms on so-called dark patterns. So I just wanted to address this topic. Is there maybe a chance through the banning of dark patterns for data privacy, or also what could be done more in this direction?
I don't know who wanted to take that. I'll just also note that in the AI Act, there's also a line about subliminal manipulation, which most people take to mean marketing like that.
I think that's a very fair point. Like, for example, as I described before, the way we are building controls in the metaverse, like in the tools that allow users to go into the metaverse, but even like on the specific services that we offer on Ray-Ban Stories, our ER glasses, we are really trying to avoid this kind of approach where users are pushed to consent. Frankly speaking, also consent is not the only legal basis on the GDPR. There are other legal bases, and I think, for example, if you take legitimate interest, I think it's a very interesting way to approach data processing when it's about when a service provider is using legitimate interest, because it's forcing the service provider to run a balancing test that has to be solid and has to be justify why, for example, the service provider is not going to consent. So I'm with you, and actually I hope that the industry will develop standards to go in this direction, the direction of having a more a more sort of robust dialogue with users that is not just based on consent.
Thank you very much, Marco. And with that, thank you very much to the panel and the hosts.
Well, yeah, thank you, Patrick, for excellent moderation, much appreciated, and thank you to our speakers in this session, and indeed to all those who've contributed across the day, including you. Thank you very much. Good to see you, Leonardo. I'll say hi now. The fact we've had so many of you still here at this point, I think is a testament to the discussions today. And I should probably also make a small apology for how busy it's been. We underestimated slightly how many people were going to be determined to come despite the transport disruption. So thank you again for making the effort, much appreciated. Thanks again to our conference sponsors, Baker & McKenzie, Broadcom, Intuit, ITI, Meta, User-Centrics and Workday. And if you all have time for a quick drink before you leave, there's drinks in the lobby waiting for you, so you're very welcome to join straight after I close. And so with that, on behalf of the Forum Europe team, I hope you found today beneficial. And if we don't see each other again before the holidays, and I hope it's, well, appreciate maybe it's a little bit early to be saying this, but Merry Christmas and a Happy New Year. So thank you very much.